I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, in accordance with the governor's emergency order number 12, pursuant to executive order 2020-04, this is a public body authorized to meet electronically. This is a public hearing with the potential for executive sessions to be held throughout. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and the select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform, and the public has access to contemporaneously listen and, if necessary, participate in this meeting by Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice of this meeting complies with House rules and RSA 91-A. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. I want to introduce the staff that are on the meeting assisting us. Brad Greenland, who is the committee researcher. Please note that all votes that are taken during this meeting shall be done by a roll call vote. Let's start the meeting by taking a roll call attendance. When each member states their presence, please also state whether there's anyone in the room with you during this meeting, which is required under the right to know. Madam Clerk.
Vice Chairman Wells.
Here.
Representative Burt.
Here, and I'm with Representative Hopper.
Representative Hopper.
I think I'm here.
Representative Green.
I'm here.
Representative Wallace.
Present.
Representative Testerman.
Here.
Representative True.
Present in the committee room.
Representative Pratt.
Yeah.
Representative Doucette. The clerk is present. Representative Harry Gafford.
Present.
Representative Pantelakis.
She's gonna be late.
Representative O'Hearn.
Present, alone.
Representative Bourdonnais.
Present, alone.
Representative Muse.
Here and alone in my office.
Representative Newman.
Present, and my wife is in the house.
Representative Bolden.
I'm present, I'm at home. There's family and pets.
Representative Conley.
Present.
Representative Klein Knight.
Present.
Representative Bradley.
Present, and I'm here with my daughters.
Chairman.
The chair is present.
Mr. Chairman, we're waiting for Representative Doucette and Representative Pantelakis.
When the members do join us, we will just note for the record that they are now in attendance. At this time, Representative Green is going to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
This time we'll open the public hearing on House Bill 178. which I don't have. Ryan sponsor. Have us.
Chairman?
Thank you.
Morning, members of the Criminal Justice Public Safety Committee. I'll keep my testimony very brief. I'm introducing this bill. This is the bill that we passed in the committee last year, I believe, unanimously, and I believe it passed on the consent calendar. However, by the time it made its way to the Senate, due to the COVID-19 pandemic, this bill was tabled in the Senate and not acted upon. So it was been refiled. In the interest of the committee, I will yield my time to Madam Speaker Donna Sitek, who is in attendance today, who would be able to explain the bill a lot better than I can. And just a history lesson, this committee was actually established by Sitek, and the first chairman will be appointed by Madam Speaker Sitek as representative as well. So I find it fitting that we preside over this hearing. So we listen to our speaker. That's enough. And I'll yield questions for the executive session.
Thank you very much. Here at this time calls Donna Sitek.
Somebody's got their audio on. So we hear.
Can you hear me now?
Yes, yes.
It helps if I unmute. Good morning. For the record, my name is Donna Sitek. I am a 10-year member of the Parole Board, and I am offering this bill on their behalf. We requested this bill last year in response to observations from the performance audit that was conducted, and to update some sections of our chapter to improve efficiency and assure public safety and reflect our actual practice. As has been said, this committee passed this bill unanimously last session, but it was a casualty of the shutdown because of COVID. So here it is again. So for the benefit of those who didn't hear it last year, I had provided my testimony. I had emailed it to all the members. I don't know whether you have it or not, but anyway, I'll walk you through the bill if you have it in front of you. Sections 1 and 2 are truly housekeeping provisions because we're repealing RSA 651A, which has to do with hearings at 9 months. We need to repeal it as a cross-reference in the involuntary commitment. So that's just a housekeeping thing, sections 1 and 2 of the bill. On section 3, unless you have the whole chapter in front of you, you can't figure out what's going on. In the definition sections of the chapter, it defines nonviolent crimes as all the crimes except for the ones in 651.513, which are 8 crimes. And in my handout, I've listed them. It's, first degree murder, robbery, aggravated felonious sexual assault, kidnapping, arson, 8 crimes. And it said, and the definition of nonviolent crimes also lists 8 other crimes having to do with violation of protective order, second degree assault, reckless conduct, stalking, tampering with witness, felonious use of firearm, 8 separate crimes. So since there is no reference to nonviolent crimes in the chapter anymore, that's a remnant of Senate Bill 500 from 2010 that has been modified so many times. So rather than define nonviolent crimes, which is a phrase not used in the chapter, we're going to define the violent crimes, the 8 that are listed in 651A5, and also the 8 that are currently listed in the chapter. And the reference to violent crimes is important because it's used in determining the length of any parole revocation. Okay, section 4 of the bill, which is on page 2 on the top, is a recommendation from the LBA audit. The current law requires a 15 to 30-day notice requirement to the county attorney, to the police chief, and to the victim, and to the public before the hearing. The audit observed that the statute didn't distinguish between release hearings, revocation hearings, reconsideration hearings, and review hearings. So those are the 4 kinds of hearings we have. Other than the release hearings, revocations, reconsiderations, and reviews can only result in either extending the period of incarceration for somebody who's already been approved at a duly noticed hearing. We don't think there's any need to notify the police chief, the county attorney, every time we see this person who's been approved for parole again. The right to know law still applies. So we do post notice of all kinds of hearings on our website. This just clarifies that the 15 to 30-day notice to the police, the county attorney, the public, and the victim applies only to release hearings. Section 5 makes several changes in that affect the length of committal for parole violations. So somebody's on parole, they commit a parole violation, they come back to us for a revocation hearing. At that hearing, if they are found true to have violated, the board is guided by this section of the law with regard to what kind of a sanction we can impose. The general sanction for any violation of parole is 90 days. However, we can give more or less if it meets certain other criteria. But in the instance of the standard 90-day setback, the statute would require that we release them after 90 days, even if they hadn't completed their programs, even if they didn't have a place to go, even if they didn't have treatment set up in the community. We would like to change the law to specify that violators who get the 90-day sanction meet the criteria for parole before they're being released, just like everybody else who is released. People who have a 90-day setback should meet the criteria for parole. And I've listed the criteria of parole on the back of the handout that I provided. We have had inmates, I mean, they all know, they call it a 90-day mando. I'm out of here, I don't have to tell you where I'm going. It's hard to supervise somebody if you don't know where they're going. So we need this. We need them to meet the criteria for parole. The second change is to modify the reference to the dynamic risk factors for sex offenders who violate their parole. It's a practical matter. If you're a sex offender, we don't care whether you violated your dynamic risk factors. We care that you're a sex offender and you violated parole. So you should be eligible for more than 90 days in certain cases. So we're eliminating the reference to the dynamic risk factors. The next section also, it's on page 2, line 26, and also on page 3, line 14. This corrects a mistake in the list of violent crimes. You saw in the current list of non-violent crimes, it says all crimes except for these 2 categories, 8 that are listed in one section and 8 that are listed in the statute. Well, they forgot to carry it over to the section on the length of time we're allowed to recommit somebody, the length of the setback. This is when the definition of violent crime comes into play. So we want to make clear that if you violate any of the 16 crimes that we've listed, you are eligible for either an enhanced sentence. Excuse me, I'm sorry. You're eligible for an enhanced sentence, or you're eligible to have a reduced sentence. So that this corrects a mistake. Also on page 2, line 34, we're eliminating references to the focused evidence-based programming aimed at re-engaging parolees in their parole plan. As envisioned in Senate Bill 500, there would be a 90-day setback for everybody, regardless of whether it was your first or second or what your crime was. They were supposed to have a special program in a separate place to engage parolees in their, re-engage them in their parole plan. This never happened, both for budgetary reasons and also because everybody doesn't need the same program. Right now, they design programs about the needs of each of the inmates. So this bill repeals the reference to that specific program, which never existed. Section 6 removes the requirement that the parole board review every parolee's file every 3 years. That's never been done by the parole board in its 30-something years of existence, because it's already being done by the chief of each of the district offices. So it's a burden for the parole board if we were to do it, and it's already being done. So nobody gets lost in the system. Section 7 of the bill contains 2 repeals. Right now, we have a provision in the law that says applications for parole can be heard in non-public session. But our rules have long allowed anyone to get an audio recording of parole hearings. So when I came on as chairman, I said, this is crazy. If you can get an audio hearing, why can't you be there? So I opened up the parole hearings to the public. So we have been conducting them in public. The LBA pointed out this discrepancy. So this bill cures that by doing away with the section of the right to know law that says that parole hearings will be heard in non-public session. Parole records, however, will continue to be non-public. And the last provision of the bill on page 3, line 29, eliminates the requirement to hold a parole hearing for an inmate 9 months before his max. Under Senate Bill 500, as originally envisioned, everybody would be automatically released if they were still there 9 months before their maximum sentence. Regardless of their behavior, they would just be released. That law was changed so that they are entitled to a hearing 9 months before their max. Okay, so they come into us, they have a hearing, but they don't have a plan. They've had terrible disciplinary rate. There's no way they're going to be released. So this bill does away with the requirement that we have the hearing. You should know that this doesn't take away any rights from any prisoner. Anybody who is here as long as 9 months before the maximum at any time, when they've got their housing plan, when they've completed their program, when they meet the criteria for parole, they can ask for a hearing. So this doesn't take away any of their rights. It just takes away the requirement that we have a hearing for somebody we know isn't ready to be released. So the passage of this bill will enhance our efficiency and effectiveness, and I hope you will support it as it ought to pass, just as you did last year. I would be happy to answer any questions you may have.
Any questions from the committee?
I guess I've said it all.
Hopefully we'll do the same thing we did last year.
Thank you, Mr. Chair. Thank you very much for taking my question. On
Somebody's not muted. Somebody is now.
and thank you for taking my question. Can you tell me what a dynamic risk factor is?
The dynamic risk factors are those that can be changed. Homelessness, loss of support, substance abuse, non-compliance with treatment.
Thank you.
Are there any further questions from the committee? Seeing none, we thank you very much for your testimony.
Thank you, Mr. Chairman.
Have a great day. Anyone else?
Check, Mr. Chairman.
No one on the list.
Mr. Chairman, I see no one with their hands raised. No, I don't see anybody, Mr. Chairman.
All right, and I guess we will close the public hearing on House Bill 178 FN.
And Mr. Chairman, we had 2 people signing in support of the bill and 5 people signing in opposition.
Weird number.
Well, we have some time. Testament. Can you find Chairman out in the hallway?
Take your time.
There you go.
We're fast. Here right now.
We close the hearing. Open to suggestions.
I just need a finish reflect of what's going to be said of the vote. This time, we're going to open the executive session of House Bill 178 relative to the parole of prisoners and the procedures of the adult parole board. Chair recognizes Representative Welch to make a motion.
I make a motion, we find House Bill 178 FN ought to pass.
I'll second it.
Has been seconded by Representative Burke. Representative Welch, do you wish to speak to your motion?
Well, this is the same bill that we passed last year. Most of us have heard it before. And the request, it answers some of the problems that are outlined in the audit. So I think we, good bill, pass it.
Thank you, Representative Welch. The chair will now open the question up for discussion. Seeing Representative Newman, you're recognized.
Thank you, Mr. Chairman. My only concern, that was an excellent summary of the bill. The bill. And my only concern is there are a lot of laws that we're going to be considering that have to do with parole, and some of the wording has been changed in there that relates to parole. So we probably have to refer back to that and see how the two things might conflict when we consider those other bills. Thank you, Mr. Chairman.
Thank you, Representative Newman. Seeing no hands raised, clerk, with the question we put forward, the clerk will now call the roll. If you're in favor of the motion of ought to pass, please say yay. If you are opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Burke,
Yes.
Representative Hopper. Yes. Representative Green,
Yes.
Representative Allen.
Sorry, guys.
And just a reminder,
Is the House computer muted?
No.
Representative Newman, we're in voting mode, Chairman.
I would just remind the members in the room that also make sure that your speakers are also muted as well as your microphones.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Doucette.
Yes.
The clerk votes yes. Representative Harry Gathright,
Yes.
Representative Pantelakis, Representative O'Hearn,
Yes.
Representative Bordenay,
Yes.
Representative Muse,
Yes.
Representative Newman,
yes,
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman.
The chair votes yes.
Mr. Chairman, the vote is 20 yea, 0 nay.
By a vote of 20 yeas and 0 nays, motion ought to pass has passed. Consent. Have you my majority report?
All right.
I was asking you that question.
That's his chairman, right?
Chairman should write it. The chair's gonna ask, we're gonna approve.
I'd like to,
Thank you. This time we'll close the executive session on House Bill 198.
Jennifer, was it 21 or 20?
20.
Who's out?
Representative Pantelakis.
Thank you.
You're welcome.
Representative President.
Yes.
On the website. This time we were gonna reopen the executive session on House Bill 238. And I believe at the time that when we recessed, there was a motion to please speak to legislate that was made. Representative Tesman, you recognize?
Yes, I'd like to withdraw my ITL.
Although it's not required for that to be seconded. Is,
I second that.
Representative Knight has seconded the motion ITL. Representative Knight seconds the motion to withdraw the ITL. Representative Welch, do you wish to be recognized for a motion?
Yes, I'd like to find House Bill 238. We should retain that.
Representative Wall?
Second.
The motion to retain has been seconded. Madam, the question now be open for discussion. Representative Bordenay, you're recognized.
Thank you, Mr. Chairman. It was clear on Monday that I had no idea what this bill did or the laws that really were affected. Since that time, I've taken the time to educate myself by talking to attorneys, and I see no reason to retain this bill. I think that we should rule it inexpedient to legislate. This bill would add an exception to the provocations section of, well, it's not a law, but the provocations, and I see no reason to do that. Those provocations are a high enough bar to clear without making exceptions. So if you want to retain it, I'll vote for it, but I really think the motion should be inexpedient to legislate. Thank you.
Representative Bradley, you're recognized.
Thank you, Chairman. I think this bill should be ought to pass. I feel, especially, I mean, what we saw on Monday it definitely shows that this bill is needed. It was unexcusable, and I don't know how we could retain this bill. So I'll be opposing.
Representative Newman, you are recognized.
Thank you, Mr. Chairman. My feeling about this bill is I think it's an important bill that it ought to pass, but I don't see a great likelihood of that. So therefore, I will reluctantly vote to retain it so that we can have the opportunity to work on this bill sometime in the remainder of this session. Thank you.
Representative Muse, you are recognized.
Thank you. I also believe that we should be voting ought to pass on this bill. I think the folks who testified made an extremely compelling case on Friday as to why this bill should pass. I also think that some of the issues that people in the LGBTQ community face when it comes to getting a fair shake in the courts and getting a fair shake in the legislature were exposed on Friday. And I believe that this legislation is necessary, and I will oppose the motion to retain it.
Representative Jaffer.
Thank you, Mr. Chair. I too propose to retain. I think that it should go forward as ought to pass. There were compelling testimonies on our last group session, and just in lieu of what transpired that day, it definitely ought to pass.
Representative Conley.
Thank you, Mr. Chairman. I agree this bill should be ought to pass. The bills that this committee has retained have been complicated. There have been easily identifiable issues that need to be resolved through a subcommittee or an intense work session. I don't see any of those issues with this bill. It seems like we understand what this bill intends to do. I think we can recognize the problem it intends to address, and seeing no real things that needed to be fixed, I would suggest ought to pass, and I'll vote no on retaining.
Representative Knight.
Thank you, Chair. With all due respect, I think we're making a horrible mistake here. I think this needs to be ought to pass. We have some of the highest LGBTQ communities population in this state, and we couldn't even respect them enough to give them their own hearing. We lumped it in with another bill. And on top of that, we had a member of this body.
And
can you actually warn me before you just...
You're not recognized to speak at this time, Representative Knight. You're now speaking out of order. And to the extent that anyone found the scheduling of these House bills disrespectful, that point of order is no longer proper. It should have been addressed on Monday during the public hearings. The chair is going to exercise his discretion and not recognize anyone to speak a second time. And anyone who hasn't spoke already who wishes to speak, please raise your hand. Seeing no hands raised, no matter with the question, the clerk will call the roll. If you're in favor of the motion to retain, please say yay. If you're opposed, please say nay.
Vice Chairman Welch.
Aye.
Representative Burke.
Yes.
Representative Hopper.
Yes.
Representative Green.
Yes.
Representative Wallace.
Yes.
Representative Testerman.
Yes.
Representative True.
Yay.
Representative True, you said voted yes.
Yay.
Representative Pratt.
Yes.
Representative Doucette.
Yes.
The clerk votes yes. Representative Harriet Gathright.
No.
Representative Pantelakis. Representative O'Hearn.
No.
Representative Bordenay.
Representative Bornay, you need to turn on your camera and you are also muted. And it would be easier if the members left their cameras on while we're in the voting mode.
Sorry, Chairman. I vote no.
Representative Hughes.
No.
Representative Newman.
No.
Representative Bolden.
No.
Representative Conley.
No.
Representative Bradley.
No.
Chairman.
The chair votes yes.
Excuse me, Chair, I didn't get called to vote.
The representative was not in her seat when
If you'd have
Come
paused.
on, I was right here, you could see me. Come on. You're telling other members that don't have their camera on.
Representative
voting of the
Knight,
chair.
please control yourself, Representative Knight. You've been warned. The member was not, we can see the seat, the member's camera's on. When the matter of question was called, she was not, the member was not in their seat. Therefore, they are not allowed to enter the room. So that's the ruling of the chair. But
The vote is 11 yay, 8 nay.
by a vote of 11 yeas and 8 nays, the motion to retain is passed. We now close the executive session on House Bill 238. And we will be in recess to 9:45.
Mr. Chairman, I'd like to ask you a question.
versus, Representative Gabbard is the prime. At this time, we are opening the public hearings on House Bill 598 and House Bill 138. House Bill 598 is relative to the portion of a minimum sentence to be served to be eligible for parole, and House Bill 138 is allowing prisoners serving a life sentence to be eligible for parole after 25 years. At this time, the chair recognizes Representative Gathering.
Here, or do I have to go?
The middle chair. Representative Gathering is recognized to introduce House Bill 598.
Morning. In the 1980s, we saw a wave of so-called get tough on crime policies. These included mandatory minimums, 3 strikes laws, and a policy known as truth in sentencing, which required that people serve a certain percentage of their minimum sentence before being eligible for parole. These 1980 policies were extreme, and we spent the past few decades walking them back. This committee passed legislation already this session to remove some of the remaining mandatory minimums that we still have on the books here in New Hampshire. This requirement has prevented New Hampshire from being able to grant time off for good behavior, meaning for decades we have lacked the ability to incentivize rehabilitation, a central purpose for incarceration. Moreover, truth in sentencing has resulted in people spending more time in prison, meaning a higher price tag for taxpayers, who have to pay for every day someone spends in prison, with 1 year in prison costing taxpayers roughly $40,000. Truth in sentencing is expensive, extreme, and outdated. Many other states have repealed or amended their truth in sentencing laws, including those states that had less extreme versions to begin with. And I say that because New Hampshire was the only state during that time that went for 100%. The 1980 notion that if we just extreme enough in our punishments, we could deter or even end crime has been consistently disproven. Extreme sentencing causes far more harm than good. The goal of incarceration should be rehabilitation, and we need to amend our policies accordingly. HB 598 would amend our truth in sentencing law to require that people serve 50% of their minimum before being eligible to apply for parole. Being eligible for parole does not mean that a person will automatically be paroled. It means they can apply and the parole board will make a determination on a case-by-case basis. Let me be clear. This legislation will not automatically result in people let out of prison sooner. It simply swaps a one-size-fits-all policy for one that allows the parole board to consider the unique circumstance of an individual's case, their rehabilitative journey during incarceration, and whether or not to grant parole. In 2015, approximately 30 states had this law, and we call it TIS. The District of Columbia have them in place. In contrast, states like Indiana, Texas, Maryland, and Nebraska say inmates must serve at least 50% of their time. allow my time to others that have done more research and can speak more to the issue. Sorry. Question?
Seeing no hands raised, want to thank the representative for her testimony. And I would just clarify this rule right now. Generally speaking, when a representative who's a member of the committee introduces a bill, they're not permitted to ask any questions. However, we're hearing two bills at the same time. So Representative Gabbard, you will be permitted to ask questions of witnesses in regards to House Bill 138. But if you do ask a question, please just specify in regards to 138, just to make sure everything's clear.
Mr. Chairman.
And we're gonna keep the hearing going. At this time, the chair recognizes Representative Abramson to introduce House Bill 138.
Mr. Chairman, I'm not seeing his name. Oh, no, I see it there. Sorry, Mr. Chairman. Yeah, he's on. He's unmuted.
Oh, are you able to hear me?
We can hear you, Representative.
All right, thank you. I'm sorry about the audio situation there. My name is Representative Max Abramson, representing Seabrook, Hampton, and Hampton Falls. I'm introducing House Bill 138. This is the same bill that I introduced last session, guaranteeing a 25-year parole hearing at the 25-year mark. And I want to start by answering some of the questions that I got last year that I had to do some research on. The first question that members of the committee asked was, you know, what percentage of people who go to a hearing actually get paroled? And I decided to go ahead and pull up the numbers from other states. And it's all over the map. Most states are in the 20-some% to 30-some% range. So most people get a parole hearing are denied and go back into the system, but they get another shot in the future. There were two outliers, I believe, Michigan and Nevada, that had, I believe, a 69 or 70% parole rate or release rate. There are three basic reasons for putting this in. The first reason is for correctional officer safety and stress. As far as why I put it in, after I spoke last session on repeal of the death penalty, literally as I sat down, another member said to me, okay, well, what about safety of correctional officers? And he brought up an exceptional case. What if you have someone serving life in prison, you take away the death penalty, and now there's no incentive for an inmate who might be violent. Some of the 4,000 inmates, there's a small percentage who are still extremely violent and should never be released. And what prevents them from killing a correctional officer? And I thought about the correctional officer safety first, and then thought about the stress levels. I noticed some years ago that we were discussing the high stress levels of corrections officers, and it's contributing to a lot of turnout, but it's also contributing to a lot of stress and health problems for those who are serving in our prison system. So I thought, well, if there's just even a possibility of a parole hearing somewhere in their future, they're a lot less likely to take the life of another person, another inmate, a visitor, or correctional security personnel. The second reason that was brought to my attention, I think after I put the bill in, was that when inmates are very old, when they get into their 60s and 70s, they develop more and more severe chronic medical conditions. And I'm looking forward into the future, not just under the current pandemic, that they have to have specialists coming into the prison. Well, a specialist coming into the prison has to take an entire day off from work in order to drive out to the prison and see an inmate. And the costs of those types of visits are extremely expensive, and they become more and more common as the inmate gets older, more feeble, and as their chronic conditions get worse. And that's exactly at the age, 70-year-old inmates are generally not statistically a danger to society, even if they may have been a danger when they were 18 or 20 or 25. Certainly when they're in their 70s, the chances of them going out and committing another violent crime are very, very slim. And that's part of the reason why parole boards are much more likely to parole an inmate who is much older. And they do so on second-degree homicide cases. Second-degree homicide, where it's unplanned, either crime of passion, spur of the moment, or under duress, manslaughter, or second-degree, they are getting paroled, especially if they are older inmates. They have a right to a parole hearing at 18 years. This would just simply guarantee it at 25 years. And the third reason, and I think the most important reason for me, is the number of wrongful conviction cases where there were some clear-cut cases when I started investigating New Hampshire's wrongful conviction cases, but there were some gray areas where even I wasn't certain. Someone is maintaining their innocence, but I'm only about half certain that they really were innocent. I'm not going to name names, but where there was some evidence of wrongdoing, but maybe not enough to secure a criminal conviction. In my own self-defense case, I did a lot of research on forensic methods, and most, if not all, of the forensic methods that were being used to convict people 25 years ago have been proven to be completely invalid. Congress commissioned a study, I believe in 2001, that produced a book called Strengthening Forensics, A Path Forward. That book didn't come out until 2010. And it's a very worthwhile book. I think it's about $55. I think that every member of the committee should, maybe even every member of the House should get a copy of that and see some of the problems that have existed in forensics. Every single method that they examined, from blood samples, hair samples, fingerprints, everything except for nuclear DNA testing had proven to be either invalid, junk science, or needed to go through additional scrutiny, that you needed to have corroboration by another forensic expert. And one of the criticisms of Innocence Project as they went through these cases is they found that defense attorneys often weren't even cross-examining forensic experts, that forensics methods were once thought to be irrefutable and unquestionable, and now we know that the error rates can be as high as 50 or 60% for some of them. So a parole hearing would just kind of be one last line of defense. It allows human beings to reopen the case, take a look at evidence that was not heard by the jury, in particular evidence that has only recently become available, or cases where the forensic methods used to convict people, the transcripts, were brought under scrutiny after the trial and found to not be consistent enough, or may not even be admissible in court anymore. And of course, I'll take questions.
Thank you, Representative, for your testimony. Representative Hopper?
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. I have personally witnessed, I think, only one parole hearing, and I thought parole hearings were to try to determine whether the parolee or the inmate was safe to release into the public, whether their behavior in prison and things that they've done in prison justify releasing those people into the public. Is it the case that parole hearings are also used to retry a case?
Not usually. You're right that is the number one reason that they do psychological evaluations, and they'll even talk to people who work in that particular facility. The number one issue that they're concerned about is that person, have they gone through the reforms that they need to go through? Have they done the work? Have they admitted responsibility for what they've done? The number one question, and I have a friend in town who was on the parole board for a long time. The number one question on their mind is this person safe to go back out into the community? However, parole boards, people are allowed to bring in evidence, and in particular, if you have something like I don't know, fingerprint or testimony or some such thing, they can draw attention to that issue and say, well, there's reasonable doubt, and usually it'll be, somebody did actually kill the person or was present, but it wasn't it wasn't at the level that they said when you negligent homicide, second-degree homicide, manslaughter, and other charges. If evidence is sometimes kept out by the judge because the judge doesn't understand at the time of trial the severity of the evidence, or they just sometimes exclude it because the defense attorney didn't, I guess, sell the witness or explain what the witness was going to say in enough detail. There are all kinds of problems and things that happen at trial, and the parole board does sometimes look at evidence to see if it's an overcharging, over sentencing, or wrongful conviction.
Thank you.
Thank you, Representative. And Representative, the chair would ask to inquire a question. And I want to thank you in advance for taking my question. In respect to lines 9 and 10 of House Bill 138, it reads that basically expressly exclude any person that has been sentenced to the death penalty before the effective date. My question is, if that sentence were to be commuted, would that particular individual be eligible for parole after 25 years?
No, they wouldn't. That's I think we all know who we're talking about. I put that in as a personal issue. I knew Michael Briggs, and he was a very professional model officer. I didn't want this being used in any particular way to help his killer get out. Now, the bill is in front of the committee, and if the committee wants to delete that, that's your decision. But my preference would be that the killer in question deserves the sentence that he got, and maybe even worse.
Thank you for taking my question. Representative Muse?
Thank you, Mr. Chair, and thank you for taking my question. I'm curious, just what percentage or how many people are currently in the prison system who might be eligible for something like this?
That's actually a good question. The methodology used in the bill, the Department of Corrections indicates that there are 114 individuals that would be eligible for parole before the minimum sentence, and 75 individuals that would later become eligible for parole review that are serving life sentences without parole. So it's a grand total of about 190 individuals. So it's less than 5% of the prison population, but this is one of those bills that's more of a matter of principle. And yes, it's not a very large number, but it's just the need to have kind of one last line of defense, to have human beings who have the ability to go ahead and release someone under extraordinary circumstances.
Representative Muse, you're recognized for a follow-up question.
Thank you, Mr. Chair. We heard in testimony on a previous bill, which was actually in some ways related to this bill, that one of the reasons for not automatically granting a parole review is that sometimes a prisoner simply may not be ready for it, or may have been violent in prison, committed other offenses, and that's one of the criteria that the parole board uses. How does this bill address situations where an inmate may reach this point but not be someone that we would necessarily want to parole back into society?
Well, the parole hearing is only the hearing itself. The question of release, it's only a minority of cases where the individual actually gets released on a first parole hearing. So if someone continues to remain violent in prison, or causes problems, or refuses to accept responsibility, or literally a few of these people still have the same attitude 25 years later, and those people are not released. I don't have a problem with going through the time to have that person have a parole hearing, but in that particular case, I think that the benefit of the parole hearing is to have an additional group of people looking at that person's case and their history in prison and say, there are other people who are worthy of release. And if you're going to continue to conduct yourself this way, we're not going to release you. The possibility, even though it's a long shot, the possibility of parole and release is kind of an incentive that the correctional officers and the warden sometimes need in order to control the population and keep the prison itself safe, and take some of those individuals who are serving life in prison, who now, for a lot of them, they're thinking, hey, there's no reason not to hurt someone. There's no reason not to commit another crime, or even rape, or commit murder while they're there, if they're facing life with no possibility of parole. There has to be a slight possibility of parole. There has to be a slight possibility of release in order to get them to shape up.
Thank you.
Put it on through.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. You gave a number of 190 people in prison who would qualify or may eventually qualify. Is that 190 in prison for life without parole?
Yes, those are all what they call LWOP, or life without parole cases. And I believe, according to Legislative Services, the only type of case right now under state law is capital murder, or first degree murder, I should say, that only a premeditated murder. So there would be, I think that's 189 cases. We get a couple more every year, but that's the number.
Thank you.
Other questions by the committee? Non-testimony.
Thank you, Mr. Chairman. Thank you, Representative Abramson. Is your feeling that percentage-wise there are too many prisoners? I mean, do we as a whole have too many prisoners in our prisons compared to other states?
Compared to other states, I think that we have a smaller percentage, but back in the 1970s, we had 200 roughly, and now we have about 4,000. About a third are serving time for victimless crimes, a little more than a third. And actually a large percentage are just people awaiting hearings or waiting trial. One of the people working at the public defender's office said that they had a client who'd been in there for 3.5 years who had not even had their trial, and that the case just kept getting kicked down the road. So a large percentage of the people who are in corrections haven't even been found guilty yet. So, but on the bigger issue, on the bigger question, are there too many people in prison? Yes. But for the first degree homicide population, I would view them as separate. And I think that frankly, most of them deserve to be in prison. And the parole hearing that I'm proposing is just an incentive to try to keep the corrections officers safer and get inmates to reform themselves, turn themselves around.
Thank you.
Are there any other questions by the committee? Seeing none, thank you very much for your testimony.
All right, thank you. And I'll send you folks an email on the parole statistics I was mentioning.
Mr. Chairman?
Yes.
Would you mind if I called Donna Sytek and then followed with former Chairman John Thal?
Sounds acceptable to me.
All right, thank you, Mr. Chairman.
Yeah, Representative Sytek. I'm going back. Donna Sytek testifying on House Bill 598.
Good morning again, Mr. Chairman and members of the committee. I'm Donna Sytek. I'm appearing on my own behalf for part of one of these bills and on behalf of the parole board in opposition to both of these bills. While it's fresh in your mind, I want to clarify some things. The parole board does not retry a case. We don't look at new evidence. We look merely at the criteria for parole. As I have to tell victims many times who come to parole hearings, that we are not a resentencing body. The judge who's heard all the information and has heard from the victims imposed a sentence that he thought was just. So don't use this as an alternate way of appealing your case. As far as our parole rate, New Hampshire has one of the highest parole rates in the country. We parole about 85% of the people that we hear. And the other thing is the prison population is about 2,000. It has been declining. We have 500 fewer than we had a year ago. And the reference to people languishing in jail, there are no pretrial detainees at the state prison. Those are folks at the county. So just to clarify that. So back to my personal reason for opposing 138 is that it violates truth in sentencing. Anybody who knows me, who's been around the legislature for a long time, as I have, and perhaps Representative Welch, knows that I am the mother of truth in sentencing. There was a case of a murderer in 1983 who was given a life sentence, and he ended up being eligible for parole after 10 years. And there was a hue and cry, petitions. We had throngs of people at the hearings. And as a result of that, we came up with our policy of truth in sentencing. That means that the minimum of the sentence that imposed by the judge is the amount that is served before they're eligible for parole. This was to inspire confidence in the criminal justice system, so that a sentence of 2 to 4 meant that a person would serve at least 2 years before they're eligible for parole, unless the judge modified their sentence. I'm looking at 598, where it says life without parole actually means life with parole. I'm thinking of Alice in Wonderland, where Humpty Dumpty said, when I use a word, it means what I want it to mean, neither more or less. This House Bill 138 would make the minimum sentence meaningless. If the judge imposed 2 to 4, what does the 2 mean? If the goal is to motivate people to change their behavior, there are already existing provisions of the law that allow them to have opportunities to get their sentence reduced, rather than an across the board 50% discount on all the sentences without requiring some evidence of effort on their part. Current RSA 5120 allows an inmate to ask the court for a reduction of maximum after they serve 2/3 of their sentence. So it's already on the books. If they've served 2/3 of their minimum, they can go back to the judge and they can make their case that they should be eligible for parole. This happens, practically everybody asks for a 2/3 reduction. A decent number of them are granted it. They also, often as part of the sentencing, the judge will build into the sentence a provision that if they engage in a particular program, for example, the in-house drug treatment program, which is called Focus, they would be eligible for 6 months or 1 year off their minimum. But in these cases, it's the judge who is modifying the sentence. So that complies with truth in sentencing. The sentence imposed by the judge is the sentence that's served. Also, the judge can authorize the awarding of earned time credit. The legislature has provided that that the commissioner can award earned time credit, 60, 120 days, depending on what program, for educational, behavioral health, or parenting programs. They're spelled out in the legislature. But as this bill is introduced, the third reason that I'm opposed to it is that it's too broad. It applies to all crimes. Everything from the most minor felonies to murder. It applies to all crimes. If you think sentences are too harsh, you should change the penalties that are set out in the statute. And you could do it one by one. You've already done this regarding the penalties for marijuana. But rather than painting all crimes with a broad brush and saying you get a 50% discount, I think it is misguided. And also flies in the face of changing the sentence after the judge has imposed it. The judge who's heard all the facts and listened to all the victims. Further, the bill presents some logistical hurdles for the parole board. If this applies to all, it isn't clear from the bill whether it applies to those currently incarcerated or just people coming in new. If it applies to everybody incarcerated, we're going to have to double the number of our parole hearings. We're already busy, fully booked on Tuesdays and Thursdays for all day hearings. And the hearings require 15, 20 hours of preparation. So that's a lot to ask of members of the parole board. If it applies only prospectively, you're going to have some people in the prison who are eligible for parole at 50% and some that are serving their full minimum. It's a problem. As a practical matter, the parole board won't release anybody who hasn't completed their programs or who has a terrible disciplinary record. So you're getting people's hopes up. And if they haven't completed the recommended programs, for example, for drug treatment or mental health or anger management, if they haven't completed their programs, we aren't going to give them parole anyway. It's because our primary goal is public safety, and people who have not completed their recommended programs are a bigger threat to public safety than people who do complete their programs. So I would urge you to report both bills as inexpedient to legislate, and I'd be happy to answer any questions you have.
Representative Rhodes has a question.
Thank you, Mr. Chairman. Thank you for taking my question. There is something that you said that is really ringing in my ears, and I think it was along the lines of a person that is serving a life sentence. Well, I guess really it's only going to be half of that before they're eligible for parole. So really what is going on? So with that being said, can you maybe give us an example of, I know that you're necessarily not the person would be feeling this, but given what you do, for a living, maybe an example of for a family that has a family member that was the victim of one of these crimes that is so horrendous, the person has been put in prison for life, and now because 25 years come along, they're eligible for parole. What would that be like for a family to have to continue, to relive the nightmare all over again when they thought they at least had some kind of closure to give and move on with their life?
I can tell you that for victims of crimes, serious crimes, even burglaries, when the victims come in, every time there is a parole hearing, it's like the crime was committed yesterday. They have to revisit all those emotions. It is so painful for the victims who have to come in and appear at a parole hearing. In many cases, the inmate isn't going to be ready for parole, and so they are entitled to another hearing within 6 months if they're denied parole. And every time that there is a parole hearing, the victims have to relive the trauma. With regard to changing the sentence, I can remember a case where a young girl had been victimized by her neighbor. She had been repeatedly raped. The sentence that they worked out to avoid a trial was a negotiated plea. The inmate, the offender was sentenced to a certain amount of time so that he would not be eligible for parole until she was away at college. In between, the legislature enacted these earned time credits, so the guy was eligible for parole before she went away to college. And I can't tell you how traumatic that was for the girl and for her family. So I'm glad you brought up the effect that this kind of policy change would have on victims, because it is real.
Are there any other, Representative True has a question.
Thank you, Mr. Chair, and thank you very much for taking my question. You admit, I believe you said that In New Hampshire, 85% of prisoners get paroled. By that sentence, are you saying that 85% don't serve their maximum?
Right. The sentencing policy in New Hampshire is they impose a minimum and a maximum. They are eligible for parole at their minimum. So 85, I don't have the exact numbers, but it's very high compared to national standards. 85% of the people will hear on a given Thursday will be granted parole. That may be because they met all the criteria by the time of their minimum. A lot of them will postpone their hearing knowing that we would deny them until they completed programs. And so they'll wait until their programs are completed to apply for parole. So we would be, we don't parole everybody. We don't parole 85% at their exact minimum. We parole about 85% of the people who come before us. Some are at their minimum, some are a little beyond their minimum, some waited because they needed to find housing, needed to complete a program. But of the cases we hear, a large number are granted parole. Does that answer your question?
Yes, ma'am. I do have, thank you, Mr. Chair. I do have one more question, ma'am, if you would take it. Because I don't understand how the parole works. Prisoners must serve their minimum sentence. So for example, in a 2 to 4 sentence, you're sentenced 2 to 4 years.
Mm-hmm. So 2 to 4 means they're eligible for parole at the 2-year spot, the 2-year point. It means that if they're released, then they are on parole until 4 years. So 2 years behind the walls, 2 years in the community under parole supervision.
Well, question. Thank you, ma'am. So my question would be, if they earn a whole bunch of time off credits, does that reduce the
It changes their minimum. It changes their minimum. A lot of times the judge will say, if you complete the focus program, you can have a year off. And so they have a 3 to 6, they complete the focus program, their sentence changes to 2 to 6.
Thank you, ma'am.
But this is all done with the judge's approval, just to be consistent with the policy that the sentence imposed by the minimum sentence imposed by the judge is the sentence that's actually served.
Representative Hughes? Oh, I'm sorry. What? Representative Newman.
Thank you, Mr. Chair. And thank you to Speaker Serta for taking my question. In situations like murder without parole or murder sentences with additional penalties of crimes, there appears to be no minimum in that case, and are people in that situation not eligible for parole or to apply for parole, even though they may have completed all of the requirements and maybe even got degrees and are helpful at the prison and whatever, and maybe even the victim's family would be in favor of the parole if it was asked for. Could you just comment on that possibility?
If somebody is serving a life without parole, they can't get it reduced unless they go back to the judge for a sentence reduction. They don't get the benefit of earned time credits.
And would that follow up? And that would also be the case for someone who has a murder sentence. And do all murder sentences that do not include the part about no eligibility for parole, do they have a minimum sentence always associated with that life sentence?
Yeah.
Thank you very much.
Yes, they do.
Thank you.
Representative Conley?
Thank you, Mr. Chairman. Thank you, Speaker. So if we've heard today that 85% of New Hampshire inmates are paroled, it suggests to me this is a useful inducement for good behavior and reform and trying to better oneself. Does that same standard apply to inmates serving life without parole? Do you feel as though that would be the kind of inducement to just behave themselves, some kind of hope that they could maybe be let out one day?
The parole board is not a resentencing body. We just abide by the sentence imposed by the judge. As an observation, lifers tend not to be disciplinary problems. It's surprising. People who are doing life without parole, who are serving long sentences, are not disciplinary problems. And surprisingly, sex offenders are not disciplinary problems generally. Sex offenders have to usually plan their life so that they know how to control their behavior because they've had to groom their victims in many cases. So that was a surprise to me. They aren't the disciplinary problems. The disciplinary problems are the younger people who are there for drugs and burglaries and theft by unauthorized taking, assaults.
Further question?
Thank you, Mr. Chairman, and thank you for taking this unrelated follow-up. You mentioned earlier a case that seemed to spur New Hampshire's truth in sentencing changes. Is there more to it than that, or did that one case encourage the law to change in New Hampshire? Is there more to truth in sentencing changes in New Hampshire, or was it just a single case?
The impetus for truth in sentencing was the potential release of Edward Coolidge, who had murdered Pamela Mason. Murdered and raped her and threw her body in the Merrimack River. It was an outrageous crime that terrorized the community because there had been a number of other similar murders of teenage babysitters. And when he was given a life sentence, life at that time meant 18 years. He had accumulated, I believe, 8 years of pretrial credit or something. Anyway, he was eligible for release about 10 years after he went to the prison. The family was outraged. The community was outraged. There were petitions that were presented to the Judiciary Committee, which used to have jurisdiction over criminal justice issues. I was chairman of the committee at the time. There was a demand that we do something about this. And the answer was truth in sentencing, so that the sentence imposed would be the sentence served. And they said, well, where is the incentive for them to behave themselves if they just have to serve their minimum? We put in a provision, and this is in every minimus. You're sentenced to 2 to 4, and to the sentence is added 150 days of disciplinary time, which they work off at 12 and a half days a month. So instead of giving a discount for good behavior, we add on for bad behavior. So somebody who escapes loses all his 150 days that he had might have earned off the surcharge on the sentence, if you want.
Thank you. Representative Bradley.
Thank you, Chairman, and thank you for taking my question. Do you have any data about the impact of truth in sentencing on the New Hampshire population?
I'm sorry, I couldn't hear you. The audio wasn't very good.
Sorry, can you hear me now?
That's better.
Okay, sorry. Do you have any data about the impact of truth in sentencing on the New Hampshire population?
Oh, it certainly increased the prison population significantly. We thought at the time that the judges would modify their sentences to reflect that everybody had to serve their minimum. The judges didn't do that. So our prison population did grow significantly.
Thank you.
Thank you, Mr. Chair. Thank you for taking my question. So if someone comes up for parole and they are not granted parole, when's the next time they can apply for parole?
When they are not granted parole, we have to give them a reason we denied them, and they have to meet certain conditions. Okay, we're denying you parole today because you don't have a solid housing plan. Come back to us when you've got a solid housing plan. We're denying you parole today because you haven't completed the focus program. Come back to us when you are close to completion of the focus program. So we have to give them a reason. And when they meet that, the criteria that we set, they can come back before the board.
Follow-up?
Follow-up question.
Thank you, Chair. Thank you for taking my question. If we were to double the number of parole hearings, how would you handle that?
I don't know. They would have to add another day of hearings.
Just one day?
Yeah, we hear about 25 cases a day.
Yes.
And right now, the parole board members are paid $100 a day. The preparation for a day of hearings is, 15, maybe 20 hours of preparation. And then you spend the whole day for $100.
Didn't we
I'm
adjust?
saying that to people who make $100 a year. I recognize that.
You wish to be recognized for follow-up questions.
Thank you. I thought that we made adjustments to the parole board compensation last year.
That was part of the bill that died. It's not part of this bill. Part of the House Bill 2 makes a complete change to the structure and compensation of the parole board, but that's in House Bill 2. Right now, we're at $100 a day.
Thank you very much.
In order to prepare for an extra day of hearings, it would require a lot more staff time to prepare all the packets, all the information we need. We could get, 75 or 100 pages for each of the cases that we have to read. So they have to assemble all that data for us and then provide it. And we have to read it.
Thank you.
Seeing Representative Muse, you're recognized.
Yes, thank you for taking my question. One of the things that we heard last year when we reviewed the results of the audit was that there were a lot of inefficiencies in the parole board. A lot of them were budget related. A lot of them were resource related, related to not having enough staff. One of the things I guess that I'm curious about is that if there was a way to actually make the parole board more efficient, and maybe some of the things in House Bill 2 are targeted at doing that. But if there was a way to do that, would you still have the same degree of concern with the increased number of cases in the caseload?
The reason for killing these bills isn't because of the increased workload on the parole board. The reason for killing them is that it's a bad policy. House Bill 2 proposes a dramatic change in the structure and the operation of the board. It makes a full-time paid chairman, gives us an extra person in the office to help prepare all the information we need to make a parole decision, and increases the salary of the board members.
Thank you.
Seeing no further hands raised, I want to thank Madam Speaker Sytek for her testimony. At this time, the chair recognizes the Honorable John Thal.
Thank you, Mr. Chairman. Can you hear me all right?
Good name.
Good morning, Mr. Chairman, members of the committee. My name is John E. Thal Jr. I live in Whitefield, New Hampshire. I appear today as opposition to House Bill 598. As a retired New Hampshire State Police Chief, Sergeant, Chief of Police, current part-time Coos County Deputy Sheriff, and have had the honor of serving as a member and former chair of the Criminal Justice and Public Safety Committee, and currently serve as a member of the New Hampshire Parole Board. However, I appear today not as a member of those organizations, but as a victim of crime representing myself and my family. My sister-in-law was shot to death in 2004. She was executed while sitting at a breakfast table by her adopted son, who shot her in the back of the head with a gun he had stolen the night before from his grandfather. He then reloaded the gun, put the spent cartridge in his pocket, stole her money, jewelry, and took off in a car. He was captured in Western New York, where he ran a toll booth. He pled guilty and was sentenced to 25 to life for second-degree murder, although I believe the facts supported a first degree. This bill would allow him to seek parole after only 12 and a half years. While that period has already elapsed, he would be able to request parole immediately. I do not know, the committee has already been told about the sentence reduction hearings with the justices by Representative Speaker Sitek. And this particular individual has already requested such a hearing and was denied after review by the judge. If this bill should pass, it will traumatize my entire family, many of whom are deathly afraid of this person. Many other victims of crime will be similarly affected by this bill should it pass. And I humbly ask you to vote this bill as inexpedient to legislate. Thank you very much.
Thank you for your testimony.
Mr. Chairman, I just recalled something else. On Representative Abronson's bill, he talked about elderly members who are having problems and things. It wasn't mentioned, but there is such thing as a medical parole for those people who are deemed to be necessary of extreme treatment, etc.
Seeing no hands raised, I want to thank the witness for his testimony.
Thank you, Mr. Chairman.
Maybe the attendance reflect that Representative Pantelakis is now vacant. For any members of the public who wish to testify that are in attendance, please raise your hands at this time. The chair now recognizes Jay Mackey.
Can everyone hear me?
Yes, we can hear you.
Good morning, honorable members of the committee, and thank you for taking my testimony on this bill. My name is Jay Mackey. I am Administrator of Classifications and Client Records at the New Hampshire Department of Corrections. I'm speaking on behalf of the department in opposition to House Bill 598. I have submitted written testimony regarding our position. I'll briefly summarize our reasons for this, although Speaker Sitek had actually kind of stole a lot of the thunder that I was going to present, so I'll try not to reiterate everything that she said. In regards to truth in sentencing, currently the offenders are required to complete 100% of their minimum, but due to earned time credit laws and also RSA 651.20, they're allowed to get their sentences, their minimum and maximum sentences reduced. 6 months ago, RSA 651A 22A for earned time credit was just expanded to allow for many more opportunities for residents to apply for earned time credit. They can get up to 21 months or 630 days of earned time credit against their sentence. A lot more of programming is available now that we have tablets, Correctional Research Institute, where they can get 60 days for some programs completed, as well as multiple vocational programs where before they could only get it at one-time reduction. If passed, House Bill 598 would have a drastic impact on the ability of our department to provide recommended programming for the residents prior to being eligible for parole. For the most part, most of the residents go into their intensive programs, whether it be the focus program, as Sitek spoke about, or the sex offender treatment program. They don't go into those programs till about 2 years to their minimum due to needing those skills that they learn in the programs to apply to their reentry into society. Currently, if this bill is passed, we would be able to provide that programming without a major increase in staff or areas of programming to be available to us. We would recommend this bill be sent to a study committee on truth and sentencing, which was proposed last year in Senate Bill 438. I can take any questions that anyone has, even following up for questions they had for Ms. Sitek as well.
Thank you for your testimony. The chair recognizes Representative Burke.
Thank you, Mr. Chairman, and thank you, sir, for taking my question. The last speaker mentioned medical reasons for having your sentence reduced. In the hundreds of emails I got that was sent, with people's names on it from a certain group, they mentioned the high cost of medical. Is that possible for, somebody that's elderly and has major health issues to get released?
Yes, thank you for the question. Medical parole is an option. It is, I don't want to say few and far between, but it is not as common as the lengthy process that is started by the medical department at the DOC when they have to vet the amount the treatment cost, in addition to if this individual's going to be a danger to society if released. And then that all gets put together, and the parole board hears for medical parole. In my current position, I've been in it for about 3 years. I have seen maybe 2 or 3 people released on medical parole. It's not as common, but it is something that is done.
Thank you.
Representative Hopper.
Thank you, Mr. Chair, and thank you for taking my question. Because of COVID, I know that some of the programs in prison are not available, such as 12-step programs. Are the programs available to inmates to actually complete the prerequisites before they're eligible for parole or could successfully get parole because of COVID?
Thank you for the question. Currently, right now, we did have 2 focus programs for drug treatment, the intensive drug treatment program running, one in Concord and one up in the Berlin facility. Due to staffing issues, we had to temporarily suspend the one in Concord, and we are currently moving anyone on the list for focus up to the Berlin facility so they can complete it in a timely manner. Due to the opioid epidemic that we've been dealing with for the past few years, the list for focus is extremely high. A lot of parole violators come back and are assessed for needing intensive treatment, and due to not completing it in the community, failing drug court, other issues, they need to complete that prior to being released. So they kind of take a jump ahead of some of these other individuals that are sentenced instead of parole violators. So, but we do have programs running, sex offender treatment programs running. Our intensive programs are all running. I can't speak to some of the minor level of programs that we do have, but I know that they are still doing a lot of programs that we've had available in the past.
Thank you.
Representative Muse.
Thank you, Mr. Chair, and thank you for taking my question. One of the things that I'm curious about is the potential impact of this year's budget on some of the programs that you're referring to. So my understanding is that last week, Commissioner Hanks testified in front of the Finance Committee that a couple of the halfway houses and some of the educational programs for inmates would need to be shut down. And I guess if a reason to keep people in prison is so they can take these programs, the assumption would be that the programs would need to be there so that they could be completed. So what I'm curious about are any of the programs that that people would need to take or complete as a condition of release, basically under threat by the current budget?
I would thank you for the question. I would currently say no, because most of the programs that are required by the parole board are the intensive programs that we still have running. There are alternatives to some of the lesser ones like anger management. There, before I came to the DOC, there was a full anger management program that has been more of a one-on-one or a smaller group, so to speak, that they complete. I know, and unfortunately, if that does come to pass, that the halfway houses get closed, some of our residents that were in the halfway houses on work release are taking anger management in the community while they're on work release to be able to have that when they go up for parole.
Thank you.
Seeing no further hands raised, the witness is excused. I want to thank you for your testimony.
Thank you.
Chair now recognizes Donna Brown.
Hi, hello, this is Attorney Donna Brown in Manchester. I am speaking today on behalf of the New Hampshire Association of Criminal Defense Attorneys. I myself have been a criminal defense attorney for over 30 years. A great part of that time was as a public defender. After the last 5 or 6 years, I've been in private practice. I found it very interesting to listen to the other Donna Sitek today, and I agreed with a lot of what she said, except for the result. I should clarify, I am only speaking today on behalf of House Bill 598, which is regarding truth in sentencing, and I don't plan to address the change in the column LWOP or LIFER bill, so I'm only going to address the basically repeal of truth in sentencing. There's a saying that's been around for a long time that say hard cases make bad law. And I can think of 100 cases. I remember when the legislature moved the juvenile age from 18 down to 17, it was one really bad case. But the 99% of juvenile cases should have stayed, or 90% of 17-year-olds should have been addressed in the juvenile justice system and not the adult system. And that was changed several years back to make it back to 18. And, there's lots of cases. A parole board member, Sitek, talked about the Edward Coolidge case. Another person who testified talked about another murder. But the overwhelming majority of the people that would be affected by this would be inmates who committed non-violent offenses. And that's why, in order to avoid someone like Edward Coolidge getting out early, New Hampshire decided we're going to increase our prison population from 200 to several thousand in the course of a few decades. And so that's what happens, is this kind of one size fits all of we're always going to be looking at the terrible murder case, and we're not going to fix the issue with the other inmates. And I would suggest that there's ways to address that. I do agree with parole board member Sitek that cases aren't retried. In fact, I would strongly recommend against anyone going to the parole board and saying, I'm innocent, they got the wrong guy, but let me out. That doesn't usually work too well. But usually there is some relevance, though, to the underlying crime. And that is that if you went to prison for horrific, violent, or sexual, or both type of crime, the parole board wants to make sure you're not that same person anymore, that whatever led you to do that, be it drugs or some defect, that you've done something about that. And so that's what that's how that does come into the parole board. And I've been to parole board hearings for people who have had convictions for second-degree murder. As I think someone explained earlier, you don't get parole for first-degree murder, but for second-degree murder, you do. And those are, usually they last an hour and a half. Usually the Attorney General's office comes to those hearings with the victim advocate, with many times family members from the victim. There are a separate type of parole hearing for those hearings, but I say that because it's important to remember, and I know it's been said already, that there is a second step, that by changing truth in sentencing, you're not letting people out. All you're doing is changing parole eligibility. So if you did have someone who you lowered the period of time from when they could come before the parole board, there's still going to be notification of the victim's family. There's still going to be a chance to object. And as I said, almost every hearing I've had, the prosecution has said, here's something about the crime that you parole board should know in deciding whether he's ready to go back into the community. So those things are addressed. As I said, our concern is that we'll focus on one or two horrific crimes to not looking at the vast majority of cases where this would benefit the community, where this would benefit families. And be the more fiscally responsible thing to do as well as the right thing to do. One thing I've seen over the years, over and over and over, that when you give someone a long sentence, and the people who get long sentences aren't just people charged with rape or sexual assault and murder. There are some drug offenses. There are people doing 10 years on drug offenses. And when you put someone in prison for that long of time, you're really increasing the chance that their children will grow up in poverty, that their children will not have child support, that their children will not have a father who is on the outside to help them monetarily, whether they're in the family or not. So the cost isn't the extra, couple thousand of people that are in the prison. The cost goes throughout our society in terms of helping children who aren't going to have at least one parent who can help with the cost of them being raised. And I think that is all I have to say. And if anyone has any questions, I would love to answer them.
Seeing no hands raised, I want to thank the witness for.
Mr. Chair, actually, I'm trying to get my video up.
Thank you.
Representative Newman, you haven't been recognized. You're speaking out of order. Seeing no hands raised, I want to thank the witness for her testimony. The chair now recognizes Joseph Lascaz.
Thank you very much. Can you hear me?
Yes, we can hear you, sir.
Thank you, committee and chair, for hearing my testimony today. Joseph Lascaz, and I will be representing the American Civil Liberties Union of New Hampshire in support of HB 598. And I urge this committee to vote ought to pass on this legislation. As we've heard, throughout the 70s all the way up to the 90s, the US adopted this punishment only, get tough on crime perspective towards policies in the criminal justice system. And we did see things like the 3 strikes laws, mandatory minimums, and truth in sentencing. And when truth in sentencing was first enacted in 1984, but New Hampshire enacted in 1982, it required states to increase the length of prison time a person was incarcerated for and prove that they had served no less than an 85% minimum portion of their sentence established by federal guidelines. With the passage of truth in sentencing, things like parole eligibility and good time credits were restricted and in some cases effectively eliminated. The original federal truth in sentencing guidelines required only an 85% of minimums to be served. However, New Hampshire decided to distinguish itself by adopting the harshest and most extreme version of this policy, a 100% across the board. Truth in sentencing is a one-track minded policy that impedes rehabilitation. It is punitive oriented and it requires people to serve a blanket percentage across the board, regardless if they're rehabilitated or not. And it doesn't foster an environment that would be conducive to individuals changing the behavior that even landed them in prison. One concern that has come up is that HB 598 would open the floodgates of the prison system and everyone would be let out. And I just want to make it very clear, this bill does not do that. All HB 598 does is allow a person to have a hearing before the New Hampshire Adult Parole Board and have them make an informed decision about whether or not to grant the privilege of parole. this means a lot to me because, you know, I don't know what it's like to, you know, be a legislator or to write laws or whatnot, but what I do know is the effects of policies. I myself have served 13 years incarcerated in the New Hampshire prison system. I have seen every aspect of the parole. I have seen how rehabilitation is fostered and how it gets snuffed out. And I can tell you that truth in sentencing, as it is, this policy does not promote rehabilitation and is anti what we are looking for re-entering society members. I wanted to just address like just a couple of the concerns that we heard about 85% of people will be granted parole that goes in front of the parole board. That number, it doesn't represent individuals getting parole on their minimum. And one of the biggest things is having to wait for your programs to be completed, which will take people over their minimum sentences. So one, there's not a truth in the sentencing that you're getting because you're not, that the time that you're doing, that you're sentenced to as a minimum, oftentimes is not the time that you end up doing. And when we look at this, you know, we were told that this is, the time that you're sentenced to, that is the time that, you know, you're going to do, but you're adding bad time to a sentence. That mentality means that you're automatically assuming people who are going to the prison system are going to continue that behavior. That type of mentality and that message does not promote rehabilitation, and it doesn't foster it at all. And the provision about the 2/3 being granted parole, that, you know, we heard that everyone asked for it. Everyone does ask for it because everyone wants to have a hope. They want something to believe in. And the truth is, very few people get a 2/3 granted because you're petitioning the court, you're petitioning a sentencing judge who only saw the facts of your case that sent you to prison. You're asking that individual to review what you've done and be granted parole. Oftentimes people do not get a 2/3 sentence. And I know that this bill is said to, you know, inspire confidence, but this bill does not inspire confidence. Truth in sentencing does not inspire confidence in the system. It really only makes the system look extreme and inhumane. And the reason why it does that is the earned time credit system that is there. A judge has to approve that on a minimum sentence, because if they don't, a person would have to go through this whole process of filing a motion just to even get the earned time credits. And there is a reason to have concern over that because of the budget of the budget announcement. The earned time credit system is pretty much built on every single program that would be effectively cut from the budget, if that is what happens. And I can speak to that more. This is not going to double parole hearings in the sense that it's the same amount of people who would be going up for parole. Whether you're doing it at 50% of your minimum or you're doing it at 100%, it's still the same amount of people that would be getting parole. So it's not going to double the amount of parole hearings. It's just going to make people eligible to go in front of the parole board and see if they've been rehabilitated and meet the requirements of parole. We heard we're talking about the intensive programs that are running, that are used. If the intensive programs are the only things that are used to gauge the rehabilitative nature of a person, then I really caution what we are doing when we are looking at how people are ending up in front of the parole board without completing educational programs and how they are rehabilitated. We have to see that individuals need to be given a chance to continue that growth instead of remaining in an environment that is going to pull them in the opposite direction. Nothing about prison intrinsically will push people towards rehabilitation. You have to go get it yourself, and that has to be incentivized. And for these reasons and many more that I support HB 598, I am happy to take any and all questions that anyone may have.
Thank you for your testimony. Representative Newman.
Thank you, Mr. Chair. And thank you to the witness for taking my question. We've heard testimony about parole and we've heard testimony about resentencing hearings. Would you please tell me what your views are from your experience on whether you have a preference for one of those over the other? Thank you.
Excuse me, Representative, could you just repeat that? Just one, if I have a preference for what? Or which one?
We've heard, may I clarify?
Representative Newman, you were recognized to clarify your question.
Thank you, Mr. Chair. Yes, we have heard testimony about parole and we've heard testimony about resentencing hearings. And I would just like to know if you have a preference of one of those over the other as in order to accomplish people being whatever.
Thank you very much for your question, Representative. Yes, I do have a preference of parole. And the reason why is when you do a resentencing hearing, first of all, now you are taking on petitioning the court system, and that's gonna have a financial cost to both the state, who has to represent the state's interest in that. It's a financial cost to the individual who is putting in the motion, and oftentimes people don't have the financial resources to petition a court to say, hey, I really think that I qualify for being rehabilitated based on what I've done. When you have parole, what happens is you're not always granted parole, and what happens is they get to view things differently. They get to see a more detailed report and a more detailed record of what you have done during your incarceration sentence to be granted parole. I can speak for myself personally. During the first 8 years of my sentence, I wasn't the ideal or model inmate by a long shot. And the parole board treated me as such. When the last 5 years of my sentence, after I had became rehabilitated and I changed my behavior, and it showed, the parole board was able to make that determination and was able to comment on the steps that I had taken. They were able to see it, they were able to talk about it and say, this is what we're looking for, this is what we are trying to do. I mean, the whole parole hearing was recorded. So I personally feel, and what I've seen, that being able to go in front of the parole board to make your case and to have that heard is much better, because then you know what you're working on. You know, okay, well, I can go back in front of them if I work on this, and it's a wake-up call than trying to spend money to go back in front of a court to get a court hearing and go through that whole process.
Thank you very much.
Representative Bourdain, you are recognized for a question.
Thank you, Mr. Chair. Thank you for taking my question. If we pass 598 and someone is sentenced a 3 to 6 year term, and they get off with half of the minimum served, my understanding from testimony earlier today, they would be on parole for the next 4.5 years. What is life like on parole? Is it really much better than prison?
It is a world, it is a universe different than being in prison from being on parole. I'm currently on parole, and I will be on parole for the next 5 years. And my journey has revealed so many things that I did not know were subtle differences. To be able to just something so simple as to be able to wake up and look out your window and not see a 35-foot tall barbed wire wall, but to see maybe a tree or outside, that is a big difference. And what that does is that inspires connection to the community. That's a reinforcement. I have moved past prison. I am now in the community. I am going to continue doing the right thing, right? Something so small as that. Being on parole means that you are still being held accountable and that you have structure to continue the rehabilitative journey that you have started. I have to, I have to check in with my parole officer. I have to let him know everything that I'm doing. I have to ask his permission to do things, but he also sets goals. You could see, wow, you've been working for this many months straight. You have done this. You have been of good behavior. You get that relationship where your parole officer is there to encourage you and push you in the right direction because you've made parole. Prison that's not their job. They're only there to make sure that they keep security and that you do your requirements. It becomes the difference between being on parole and being in prison is one is transactional. When you're in prison, you are solely a number. You're referred to by a number. That is it. You are not a human. You are a number. Your parole officer is to humanize you because you have been rehabilitated and to continue that growth.
Thank you.
Representative Burt, you were recognized for a question.
Thank you, Mr. Chairman, and thank you for your testimony. You stated that if the prisoner, if programs, that the prisoners take or assigned to them are not completed within their sentence, that they will not be granted parole. Do you have any statistics or, paperwork that you could show that that's the case where, people that are not completed, do not qualify for parole?
Yeah, it's a parole requirement. That is a DOC and I believe a court requirement. When the court sentences you to prison, they will put it on your minimus. So it will be on your minimus. It will have a specific order from the judge, which will say you have to complete the focus program during your incarceration, or what the judge may say is you must complete any and all DOC required programming. And what that means is then the DOC can say, well, we're going to do an assessment on you when you first come in. And this happens in R&D when you first come in within the first 30 to 45 days of your sentence. And what they do is they'll do an assessment, mental health assessment. They're going to look at your crime. If you need to see a late act, they're going to do all these types of assessments to develop what type of prison plan, pretty much, that you must follow in order to be eligible for parole. So it's going to look different for each person, but one of the main requirements that is thematic for everyone is that they have to complete whatever programs the DOC or the court has required.
Thank you.
Seeing no further hands raised, I want to thank the witness for his testimony. The witness is excused. Chairman recognizes Evanor, initial P, and just please state your full name for the record, where you're from, and whether you're testifying in support of opposition to either House Bill 598 or House Bill 138, or both.
Okay. Yes, my name is Evanor Panetta. I'm testifying in support of the bill. I'm a resident of Nashua, New Hampshire. Born and raised in Nashua, New Hampshire. I was formerly incarcerated. I was in prison for 15 years. I've been released for the past 9 months. And again, I'm testifying on my own behalf as a private citizen for HB 598. And I've been listening to a lot of what's been said. There's a lot of back and forth. This is nothing new. I know Donna Svitek has been in support of truth in sentencing for such a long time, and as she said, she is the mother of the bill. But I just feel that in the past 3.5, 4 decades, a lot has changed, and not for the best. Statistics, if you want to look at numbers, the population of prison, back in '83 was, around 300. And since then, the prison population in New Hampshire has risen, I think, 600%. And I think we lead that in the country. Doesn't seem, we're at what, 2,500 roughly inmates in the prison population. Numbers have been trending down lately. But some of that can be attributed to the epidemic as of the past year as to why those numbers are trending down. And the fact of the matter is, programs are threatened. There's cases where you may go to parole, and originally when you were sentenced, you were supposed to do certain programs. I can speak personally. I was supposed to do a couple of different programs that over the years were eliminated. So I never even had the opportunity to participate in these programs, and it didn't affect me at the end when I was paroled. I'm also a person that was had filed for 2/3 reduction, the 65120 bill. I was eligible for 6 years. I got 2. And I'm super, grateful that I got anything, because in most cases, a lot of people do not get any time, any relief, no matter, how much they've done over the years to improve themselves. And I know of guys that, they got master's degrees and got very little relief, if any. Also, the earned time credit bill, it has its flaws. Again, some of those programs are now on the chopping block with the new budget that the governor is proposing and cutting a lot of the education and programming. And I think that's the worst thing that we could possibly do. New Hampshire has such great potential to be able to, do something different for their inmate population, given the small number, a lot of the, local schools that, we could potentially get involved. I mean, that's a whole nother subject, but I just think motivation, incentive is so important. And I'm going to try to make this really quick. So the best analogy I could make is, the way sentencing is now, it's kind of like socialism, and bear with me. So 2 people could commit the same crime or be sentenced to the same amount of time, and one works their behind off, goes above and beyond, and will go to parole after, when they're eligible, just as the other person who may not do anything. They could lay in their bed for their entire 7 years, and because they were not a troublemaker, these 2 people will get paroled at the same time. And that isn't fair, and if we're going to make, and again, I'm using this analogy because, capitalism, right? That's incentive based. And so a change in, giving folks an opportunity behind the walls to get that incentive to get out would be huge. So some guys are just discouraged as soon as they get in and never think to do more than they have to. Some guys just barely get by, and these two same people could get out at the same time. I'm going to wrap it up, and if anyone has any questions, I'm more than welcome to receive them.
Thank you for your testimony. Representative Muse, you're recognized for a question.
Thank you for taking my question, and thank you for sharing your story. I'm wondering, one of the things we hear a lot about in these cases is the moment when someone in your situation, the light goes on for them. They realize that they have to change, and they really sort of start the process of changing. How many years elapsed between the time the light went on for you and the time you were actually able to get a hearing?
Thank you for your question. And I think that's a great question. For me personally, I would say it wasn't like a aha moment. It was a gradual change. But I would say halfway through my sentence is when I started, almost by fault, getting involved in more programs just to get out of the unit, just to break up the monotony. There was one program in particular that really, I can kind of look back at as the catalyst for my change. And, again, it was a gradual thing. It's breaking old habits, the same habits that, led me to prison. And so I would say the halfway mark, 7.5 years, more or less, was when, I was able to start making that change. And it was gradual. And, it just kind of was like a snowball effect. And I got more momentum behind me with the more programs I did, the more education I got. And it was just, again, it was for some, it might be a single moment, but for me, I would say that halfway point kind of was like that hump I reached. I hope that helped answer your question.
Representative Hughes, you're recognized for a follow-up question.
Yes, and thank you. And what was your original sentence?
My original sentence was 18 to 36 years, and I was able to get 2 years suspended through the 65120, and I was able to get an additional 10 months through earn time. And if I could speak just about earn time real quick, 10 at that point when I was eligible for it was the max you can get without having to pay for college. College is the only other way at that point that you can max out the 23 months. Since I've been released, I know that the commissioner and I believe the legislator have been able to make some changes and add some programs to that. But so that ceiling may go up. But for the most part, and able to get the full benefit of the earned time credit bill, you need to pay for college. And if you don't have the funds, then you're not getting that.
Thank you.
Seeing no further hands raised, I want to thank the witness for his testimony. The witness is excused.
Thank you.
Chair now recognizes Nicole Parisi.
Hi, my name is Nicole Parisi. I'm from New York. I represent the New Hampshire Department of Correction of Inmates. I'm a prison wife. I actually do agree with this bill, and I hope it does pass. Being from on the other side, from an outsider, having a husband that's in the Department of Corrections, who's serving 25 to life sentence for a crime that he did not do. My question is to you guys. I would like to see if someone can answer for me. When serving life without parole for something that we're wrongfully convicted of, but also has so much evidence that wasn't the person that committed the crime, but still got life without parole, that has to serve life without parole for something that he didn't do, how does the family feel that will not be able to have life with their loved ones outside of prison if you don't pass this bill? I think everybody deserves a second chance. Also, in New Hampshire Department of Corrections, they recently just took away their educational program. Now, they're taking away a lot of programs due to funding. Also, the COVID, as we know, has gotten out of control everywhere. In prison is even worse. They can't do anything. They're locked up. You know, they're on lockdown. When they love these programs give them hope that if they do these programs, they're going to have early release. He just recently put in his good earn time for just finishing a program for educational, and it wasn't accepted. And I don't think that's fair, especially when they need hope, especially when they're trying to get out early and they're trying to make a difference. And I'm from New York, and we have the true sentencing law. New Hampshire is the only state that doesn't have it right now. And I do, as a prison wife, I really hope you guys do pass this bill. And not all inmates are dangerous. They're not all criminals. They make mistakes and they realize what they did, and they need to come back into this world and start a new life. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. The chair now recognizes Representative Maria Perez.
Thank you for the opportunity, Mr. Chair, for letting me speak. I'm calling to support HB 598 and HB 138. I believe as a humans, we're not perfect, and no one is perfect. And people have the right to have a second chance. And people who committed crimes, and most of the times, a lot of times, they're not crimes that they can, they should be convicted for a life sentence. I believe people, they should have the opportunity to be involved with programs. They can teach them different, maybe we have so many fields, so many trades that they need people to be trained. We have so many people in a lot of trades that they get retired, and then we need people on the trades. And then I believe that a lot of these people, they can be trained in these different fields, and they can get integrated to the society if we give them the opportunity to be part of our society. That's why I support these two bills, because I truly believe that people deserve and they should have a second chance to be better for not just for themselves, but for our communities and for the society.
Thank you, Representative, for your testimony. Seeing no hands raised, Representative, you're excused.
Thank you.
This time the chair recognizes Joseph Ebert.
Good morning, members of the committee. My name is Joseph Ebert. It's E-B-E-R-T. I am a captain with the New Hampshire State Police. I oversee our Investigative Services Bureau. As always, I thank the committee very much for the opportunity to speak to you this morning. I'm speaking today on House Bill 138. Although a great deal has been discussed, and I won't reiterate points that have already been made, there were a few things that I thought bared mention. One of which is the possibility that the passage of 138 may affect plea negotiations and having somebody accept responsibility for the crime that they have committed. If somebody has the ability to petition for parole, although it is clearly not guaranteed, that may very well weigh upon their decision as to whether or not to take responsibility and enter into a plea negotiation. So I think that's an ancillary or an unintended perhaps effect on the system that the passage of 138 would have. I also wanted to just point out that people who receive a life sentence, I'm not aware of anybody pleading to a life sentence. I'm not going to say that that has never happened, but people who receive a life sentence are people who have chosen to go to trial, who have, in most cases, not accepted responsibility for that crime, either because they claim that they did not commit it, which is certainly their right to do so. But I wanted to point out that the individuals who are sentenced to a life sentence had a number of mechanisms with which to not end up in that situation. And then as Representative Sytek had discussed, the purpose of that parole hearing, as I understand it, is not one to bring forward items of evidentiary value, but there is an appeals process that is in place for individuals who receive a conviction. And lastly, I would just say that having worked for over a decade in the major crime unit, which is primarily the homicide investigation unit for the state of New Hampshire, I see the terrible effects that homicides have on everyone involved. And as was mentioned before by a previous speaker, the re-traumatization of individuals, family members who have to continually go back, whether it be for a parole hearing or it be for an appeal hearing, is tremendous. That's my observation. I don't speak on their behalf because thankfully I've never been in that position, but my observation has been is incredibly traumatic for those individuals to go back through that process. So having said that, I am of course willing to take any questions that the committee members may have.
Representative Newman, you're recognized for a question.
Thank you, Mr. Chair. And thank you to the witness for his testimony and taking my question. I may have misheard you or I may have misunderstood you, but I want to be absolutely sure. You talked about no one ever pleading to a deal or downplaying, whatever they call it, that you didn't know of one. Are you making any kind of connection between a person's right not to take a plea if they're innocent, even though it puts them in much greater jeopardy for a much greater penalty?
No, first of all, thank you for the question. And again, I want to make sure I try hard never to make a true, hard, fast statement of fact, because there are always occasions when somebody may enter into a plea agreement for a life sentence to avoid a death penalty case, something like that. It's a very rare circumstance. But having said that, Representative Newman, what is so important to emphasize is I never want to penalize somebody, and nor does the Division of State Police ever want to penalize somebody for exercising their right or for penalize somebody who is innocent of a crime. What I was saying, or what I was trying to convey, and I probably didn't do in as clear a fashion as I could have, is that an individual who receives a life sentence has been adjudicated through the system. They have been found guilty. They have had their opportunity to argue their facts and circumstances, and a judge or a jury has found them guilty of that charge. What I'm saying is that that individual had the knowledge of what really happened, and they chose not to enter into that plea agreement. And they may be more likely to not enter into a plea agreement and accept responsibility for a crime they committed, not that they did not commit. For a crime that they committed, they may be less likely to enter into a plea agreement to accept responsibility for the crime they committed if they know that there is a built-in safety valve of the possibility of parole in 25 years. So I hope that clears it up, but I want to make that crystal clear that I never want somebody to engage in any type of plea agreement or plea conversation if they're innocent of a crime.
Thank you very much for that crystal clear clarification.
Seeing no hands raised, I want to thank the witness for his testimony. The witness is excused.
Thank you.
The chair now recognizes John Kittredge.
No, you
Hello?
didn't.
Hello, am I on?
No, you're not.
John Kittredge, you are recognized.
All right.
Yes. Thank you very much. I'm sorry. I had problems with the mute button. To the representatives, thank you for taking the time to listen to my support of House Bill 598. I am a criminal defense attorney in Massachusetts. I've been a criminal defense attorney for some 35 years. I've seen many people come back from prison, rehabilitated, and enter into the system. I am concerned with New Hampshire programs being cut for the inmates and them not being able to obtain credits towards their release. I think that truth in sentencing has been around for too long at this point, and I believe that that the inmates can engage in programs that can help themselves, and I think they need that knowledge that if they work on rehabilitation, that in fact somewhere down the line that they have the opportunity to be released early. Thank you very much. And if there's any questions, I'm willing to take them.
Seeing no hands raised, I want to thank the witness for his testimony.
Thank you.
The chair now recognizes Jennifer Sargent. And for any members of the public who are in attendance who wish to testify that have not testified already, please raise your hand.
Can you hear me?
Brian didn't comment.
Okay. Thank you very much. My name is Jennifer Sargent, and I very much appreciate the committee's taking the time this morning to allow me to participate. I am the chairman of the New Hampshire Adult Parole Board. I have asked Donna Sitek to speak on the parole board's behalf. She did a wonderful job. There are a couple of things that I would like to clarify, if I may. The first is regarding incentive versus community safety. Incentive, as we've heard for residents in the Department of Corrections prison, very important. Wholeheartedly agree that there should be incentives and there should be programs. Community safety is the most important thing that concerns the parole board. We have very specific criteria which we must apply in order to decide if a resident has met the criteria for parole. We consider that criteria against what the residents have done, what programs they've engaged in, but also their conduct in the prison, also their support systems outside, their housing plan, their ability to be supervised. All of the things besides programming are definitely taken into consideration, and it's not just one type of programming or another that we look at. I do want to specifically speak to medical parole. Medical parole is dictated by statute, and we also have administrative rules that further require us to evaluate petitions for medical parole. They are few and far between, however, they do happen. And I'm speaking in opposition of House Bill 598 because there are many mechanisms, and I'm not going to repeat what Donna Sitek said, there are many mechanisms, including medical parole, if necessary, in order to allow for a resident who has certain needs to be released. I want to talk to the practicality of HB 598 before the board. We have found on the parole board, and we know that unless residents do programming and they do it at first and significantly with the structure that the DOC inside the prison provides, that gives them the foundational tools to then go outside to do more treatment, more programming, and to be compliant. The fear is that if 598 were to be in effect, and if residents could go before the parole board at half of their minimum, that they would not have had adequate time given when the Department of Corrections engages them in the programming, because the Department of Corrections does look at their minimum sentences as a trigger for timing in which to enroll them in certain correctional programming, such as the focus program. If they come before the parole board, the residents, if they come before the parole board at half of their minimum, what is going to be the problem is that their programming and their development is often not going to be sufficient enough for us to find them parolable under the criteria that is in the administrative rules. What I'm saying is that they will not be sufficiently through all of the things that they need to develop so that parole will be able to find that they are going to be paroled under our very specific criteria in our administrative rules. What I'm afraid that this will do is create a false hope for residents who will be seeking parole and will have a parole hearing. Every resident, if this bill passes, will be automatically put onto the parole list, and it will be noticed publicly as we are required to do by law. The parole board will not have the option of saying, no, this person isn't ready yet for a hearing, or yes, this person isn't ready for a hearing yet. That's not how it works. What our office does is look at where they are timing-wise in relation to their parole eligibility date, which is their minimum, which would be half of their minimum if 598 passes, and they automatically get scheduled for a parole hearing. This would significantly increase the number, if it is in fact applied to residents who are already in the prison. It would significantly increase the number of hearings that would have to happen. I'm worried about the fact that we would be seeing people seeing residents too early, and they would not have fulfilled the obligations for them to meet the criteria for parole. Additionally, Donna Sitek has spoken about the effect on victims. It would create a situation where I'm afraid more often than not, victims would have to prepare for these hearings, and these hearings would more often than not result in parole because the residents would not have been able to complete enough programming and have had structure for long enough to make themselves adequate risks regarding community safety. Moreover, the staff involved and the parole board budget is very limited at this time. HB2 that we have also proposed, and there's been discussion about briefly today, is the first step in making the parole office able to handle a lot more work, adding staff, building up our potential to hear more residents on a more frequent basis. The parole board ideally would love to be full-time. That's not going to happen yet, but we believe in seeing as many residents as possible, as often as possible. That is the goal. Right now, the staffing and the resources are not adequate to overload our office with the number of parole hearings that I fear will happen if 598 passes. As a result, we will not have the ability to amass adequate information about all of the residents. It's very difficult for our staff to gather a significant amount of information from all different sources and places in order to prepare the parole packets that the parole members use. We want to make sure that we're making decisions for the residents and for the community based on the most and the best information that we can get about all of the residents and all of their plans and their accomplishments. We are pro-release. That is evident from the fact that we work hard to get as much information as we can and work very closely with the DOC so that we can release people to the community safely. But 598 is potentially going to create an onslaught that need not happen given the opportunities for earned time credit that are available, given the opportunities for medical parole that are available, and also because of the inadequacies that we have currently with staff and office size. We hope to, with HB2, get a start on trying to hear more residents more frequently. But right now, what is asked in 598 is difficult to accomplish practically on the ground for our board. And I thank you for hearing me. I will take any questions that you may have.
Representative Conley?
Thank you, Mr. Chairman. Thank you, the witness, for taking the question and for the nice presentation. Several times today, I've heard from different witnesses the discussion around programs for inmates and how completion of these programs is a requisite for being considered a likely candidate for parole. Can you offer some clarity on the timing that these programs would occur? And could these programs begin sooner to then allow the inmates to complete them sooner? And I guess that would be a good start. Would you mind doing that?
I will, to the extent that I can. And the answer to your question is, I can't tell you when certain programs are allowed to start, as that is the purview of the Department of Corrections. The programming is run entirely by the Department of Corrections, and the Department of Corrections is the organization, the body, the agency that allows and enrolls the residents in a variety of the programming that we do require. such as the focus program, mental health treatment, sex offender treatment. It is really, the timing of the programming is set by the Department of Corrections for those canonical programs. On the other hand, there are residents who can avail themselves of programs on what we call the tablet, a GTL system that allows them to complete programs that we look favorably upon. And it's my understanding those are free, and those are available to any resident with access to a tablet, and tablets are readily available. So those types of programs residents can be working on. Available on the tablet right now, there is no standalone drug rehabilitation type program that is used without being used in conjunction with a group type program, a therapeutically based program. The focus program is the therapeutically based program, and that has traditionally and continues to be a program that is monitored and requires input and design with the behavioral health staff. Additionally, the sex offender treatment program is similar in that it is not a standalone program that can be done on a tablet or as a self-learning unit. And that is also true at this point for anger management, although I have spoken with the commissioner and will represent that she is trying very hard to add a variety of treatment oriented programs to the tablet as self-learning units. It's but to answer your question, the timing for programming is out of parole board's hands. It is up to the Department of Corrections to gauge when and if it allows a resident into a particular program.
Thank you, Chairman. Thank you, Ms. Sargent. Thank you for taking my question. I do have to say, listening to you and to Donna, I learned a lot that I just simply, I guess I never even thought that I needed to know these things. But something specific I want to ask that I think that you'd be the best person from all the people that testified. So when we have an inmate that is transferred out of state, does that inmate still follow the New Hampshire, like the New Hampshire laws as far as, you know, parole or what has to be met, or would it follow that particular state?
When we have an inmate who is transferred out of state, they do still have to abide by the programming that the parole board requires. So, for instance, if someone in the New Hampshire, if an inmate in the New Hampshire system has been recommended or required to do sex offender treatment and then is transferred out of state, the New Hampshire Department of Corrections through the sex offender program and the professionals who work in that program, they're usually the ones who will coordinate with that out-of-state facility to make sure that the programming that they're able to do out of state meets the criteria of the programming that would be offered in New Hampshire if that inmate had remained in New Hampshire. If the programming in the other state is insufficient, oftentimes what will happen is that the inmate will be brought back to the New Hampshire State Prison in order to complete the programming that would be required by the professionals in New Hampshire. Does that answer your question?
I believe so. Thank you.
Representative Muse, you have a question?
Thank you, Mr. Chairman. I'm just curious if you think that the amount of time served on the part of an inmate should be dependent on things that seem to be outside of the inmate's control. And by that, I mean, it seems like programs appear, they disappear, expectations can change. And it seems like there's a lot of potential for people to fall into the cracks and even to run into various catch-22 situations in the system. Just wondering if you could comment on that.
Well, if I understand your question correctly, I think what you're asking me is a question about fairness. Is that fair to say? Like whether it is a good policy or a good practice to not consider inmates for parole until they have completed certain programming where their ability to get into that programming may be caused by a delay that is not their own.
I think that's another way of saying it.
Okay. I'm not going to answer regarding whether it's fair because we are bound to consider parole eligibility by criteria. And we also have to always consider public safety as part of that criteria, as a major part of that criteria. So the bottom line becomes whether we believe it's fair or not, how long it takes a resident to get into a type of programming. We ultimately are not going to make a decision to parole someone if we don't believe that they are not safe in the community and that they are not invested and able to maintain their re-entry follow-up and aftercare treatment. They have to be prepped and ready in the prison to go out into the community where there is less structure in order to carry on with all of the things that the programming in the prison enables them to gain foundationally. If they cannot get those things in the prison, then they are not safe to be often, I'm not saying in every case, but they are often just not safe to be in the community. That is absolutely why programming in the prison is essential. And frankly, and I'm speaking for myself now, programming in the prison should not be cut. It should be encouraged. And the commissioner is dedicated to trying to get more programming in. There are issues in the Department of Corrections that I'm not aware of because I don't work for them. What I can tell you is when it comes to paroling someone, we have to look at whether or not they meet the criteria and whether they've been prepared, entered into programming, and engaged in self-betterment to the extent that they are safe in the community and that they meet the criteria for parole. Does that make sense? If not, I'll try again.
Yes, thank you.
Okay.
You have a further question? Representative Newman.
Thank you, Mr. Chairman, and thank you for taking my question. Could you give me or the committee, some idea of how often you run into a prisoner who has met all of the criteria except the programs that are required, but runs into his minimum sentence time? And the only thing that is preventing that prisoner from being considered for parole is that the required programs have not been completed.
I don't have a definite number for you. I can tell you that because the focus program is about 6 months long, sex offender treatment can take, and it can take more or less time based on the active participation of the resident and the investment that the resident makes. Sex offender treatment, the same. Other programming, the same. Many times what happens is if an inmate is enrolled already in the programming and their hearing is coming up, they will do one of two things. Either they will postpone their hearing until they are close to finishing the program or have finished the program because they know that's, if they're enrolled, the parole board is going to require them to complete it. Or they will appear before parole and they will ask for a conditional parole. Parole me upon the completion of my program. And sometimes the parole board will do that and sometimes it won't, but we've done that often in the year that I have been on the board. What we have noticed, and this is a product of, I believe in good part COVID, but I cannot speak for the Department of Corrections, is we have noticed that the focus program, as Jay Mackey mentioned, has a very long waiting list. We are currently, residents are being brought up to the North Country facility to be doing that, as it is not currently running at the Concord facility. But there is a waiting list. Most residents who are coming in are triggering in their initial intake for substance use disorder treatment. And that requires them to go through substance use disorder treatment. There is no standalone learning unit to go through substance use disorder treatment, nor am I convinced, and this is my unprofessional opinion, that there is a learning tablet learning unit which substitutes for ASAM criteria, addiction criteria that would be adequate for treatment. So do we see people who would be eligible at their minimum, who have been on the focus list or other treatment lists who have not enrolled? Yes, we've seen an increase in that in the last year, but that may be because of limited movement in the prison due to COVID. It may be protections. It may be availability of beds. That is something that I would suggest the commissioner speak to and not myself. But yes, we have people on the waiting list that we will not parole because they have not yet been able to engage in meaningful treatment.
Follow-up, Mr. Chairman?
Yes, you may.
Thank you very much. You mentioned tablets, and tablets are readily available.
Yes.
Are those tablets available from the government, and are they free, or do they have to have someone buy them those tablets?
I don't know the answer to that. That is a Department of Corrections purchase and distribution.
Thank you very much.
Any further questions from the committee? See nothing, no hands up. We thank the witness for her testimony.
Mr. Chairman.
Thank you very much.
John, do you have anyone else on there?
I was helping you with a question about my testimony, I'm sorry.
There was one with a hand up, but it's gone, Mr. Chairman. So if there is anybody that is out there that wants to speak, please raise your hand. Mr. Chairman, I'm not seeing anybody. Let me double check. Yep, no, I'm on the right screen. No, I don't see anybody, Mr. Chairman.
Oh, then I guess we will close the public hearing on House Bill 598.
And 138. And 138.
And 138, Mr. Chairman?
Yes.
Thank you.
And, Mr. Chairman, on House Bill 598, we had 72 people signing in support, and we had 5 people signing in opposition. On House Bill 138, we had 30 people signing in support and 4 people signing in opposition.
Hearing is closed. I guess we will be in recess.
7-2 till 1 o'clock. Mr. Chairman, I think I overheard that we were going to go into recess at 12:15. Let me go get the chairman, the other chairman, if I may.
Well, we're a little early.
We are. That's why I'm thinking. I don't know what he had up his sleeves, but I think it was something. All right. Let me go check with him. I'll be right back, Mr. Chairman.
See if he's fine. Gotta love Zoom.
Why would these persons?
Not see him out there.
Yeah. What time are we supposed to start the executive sessions? 1 o'clock?
Yes, at 1 o'clock.
All right, well, the committee will be in recess until 1 o'clock.
Party.
Okay, mics are on. Look at me, look at me. Nobody reminds me to put my feet in this. I'd be trying to get across the hall somewhere. Oops, yeah. If someone's on the board, they won't get a lot. So he's with us. These two called it, so they get it set. Gerbils, hamsters, squirrels, ferrets.
Together.
Mink. Numbers. That's if you want to watch, right? That's up to you. Walk. Doesn't matter. We'll start with 436. Is that amendment down here yet? I saw her come down. I think she brought it down. Go put that on consent. Save us a 4 on that debate.
She sent it to her last night, so then she said send it again, so I sent it to her again.
We're cool in this room, Abby. You don't know it.
Okay, well, and I sent it to Laura last night, when I sent it to you.
No, I have it in my email. I'm just saying the physical copy's not in here, but as long as everyone's cool with not having it. I think with this one, we don't need it. You don't.
And was there another one? There was one supposed to be one for 205 or something?
I haven't seen that.
It's over here, thing. I don't know, is this an amendment?
Well, we can get Christian over here. Okay. That would be good. But if not, one or even two.
It's time to.
Yeah,
I think there was an amendment for 205, I was told. But I don't see it. But I heard that he sent, Shapiro sent it out, which he shouldn't, he should have sent it to Karen. And this is how we get screwed up with amendments.
Gary,
Yeah.
can you take care of the camera? Can you tell what was the consistent?
Can you ask Karen to,
Jen doesn't do it.
Amendment for 205?
Yes.
Okay.
it's all,
Oh, yeah. The top secret method. Is that gooder now, Mr. Chair?
Yes.
And Laura, hear us? Oh, she can.
Remember, okay, we're good. We're probably gonna start in about 2 minutes, so.
I'm just wondering, is that a shotgun behind her chair?
Room.
Oh, no, she can't hear me.
Can the members at home hear us? Please thumbs up, thumbs down.
Oh. Yes, you can.
I think Representative Borden gets the most phone calls.
Yes. Oh, there she is. How are you doing, Laura?
Great, thank you.
You still got that heavy purse that I'm scared of?
Yes, and I'm bringing it in, Dawn.
Oh.
I can't believe that you and I have voted so many times together.
I know. People are going to start talking about us.
Right.
What goes wrong?
It's good when we can.
That's right.
Okay, so 205.
That Evanor, is he speaking on the next bill? All the hands are down, correct?
For the members at home, to give you a heads up, we're gonna open with an executive session on HB 435, 436. Yes. Reconsideration is not to pass. Amended. It would be 3 votes.
I had it. Representative Terry Gafford, I did send that message off to Karen.
Thank you.
And she's usually pretty quick, so I'll keep watching.
But we don't need you.
I asked her to bring it down, and she has.
She's down here.
You're keeping all the copies in your office. Can you even blame you?
Well, I thought she uses them over there.
Oh, we have the one I asked her?
No,
Oh,
this is 436.
Chairman,
Yes.
Representative Kanalakis has her hand.
Good afternoon, Representative Pangelakis. Get your hand raised.
Yes, I thought we were starting a hearing on 205,
We are, we do have,
1:30.
we have 5 minutes and we're gonna try to make best use of our time to get through what I hope to be a simple housekeeping matter.
Thank you.
Good afternoon. At this time, we are going to reopen the executive session on House Bill 436. Representative Burt, you recognize the motion for consideration?
Yes, I'd like to, thank you, Mr. Chairman. I'd like to make a motion to reconsider House Bill 436.
Is there a second to that motion?
Second.
That motion has been seconded by Representative Welch. Representative Burt, would you speak to your motion?
Just briefly, I think I'll let Representative Garth Wright do most of the speaking on this amendment because she's the one that put it forth, but it eliminated any concerns that I had of the bill by removing the date. So I'm okay with the bill and I'll be voting in favor of it.
Thank you. Seeing no hands raised, no matter we put the question. Clerk will now call the roll. If you're in favor of the motion of reconsideration, please say yea. If you are opposed, please say nay. I would ask the members at home, please turn your cameras on for the duration of the vote.
Vice Chairman Welch.
Aye.
Representative Burt.
Yes.
Representative Hopper.
Yes.
Representative Green. Representative Wallace.
Aye.
Representative Testerman.
Yes.
Representative True.
Yay.
Representative Pratt.
Yes.
Representative Doucette.
Yes.
The clerk votes yes. Representative Terry Gaffray.
Yes.
Representative Kandelakis.
Representative Pendleton, you unmute yourself.
Yes.
Representative,
Yes.
Representative O'Hearn.
Yes.
Representative Bordenay.
Yes.
Representative Muse.
Yes.
Representative Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley.
Yes.
Chairman.
The chair votes yes.
Mr. Chairman, the vote is 20-0.
Thank you. By a vote of 20 yeas, 0 nays, the motion for reconsideration has passed. At this time, the chair will recognize Representative Gaffray for a motion about to pass it into law and amendment.
I move to pass as amended.
And just to clarify, is that amendment 21-0567?
Sorry. It's 0587H.
Is there a second?
I'll second it, Mr. Chairman.
That motion is seconded by Representative Burt. Representative Gabbard, do you wish to speak to your motion?
No, I think we're good.
Seeing no hands raised, Representative O'Hearn, you're recognized.
Just for clarification, again, goes towards procedure. We have to first accept the amendment and vote on that, and then ought to pass with the amendment.
Yes,
Yeah.
this is a motion the motion's ought to pass. You have to have a positive motion on the floor, which we now have. At that point, Representative Gabbard has also offered an amendment, so we are now voting
On the amendment.
on to adopt the amendment. Seeing no hands raised, the matter will be put to question. The clerk will now call the roll. If you're in favor of adopting amendment 2021-0587H, please say yay. If you are opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Burt,
Yes.
Representative Hopper,
Yes.
Representative Green, Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Doucette,
Yes.
the clerk votes yes. Representative Harry Gathright,
Yes.
Representative Pantelakis,
Yes.
Representative O'Hearn,
Yes.
Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman,
The chair votes yes.
Chairman, the vote is 20-0.
I voted 20 yeas, 20 nays. The amendment passes. Representative Gathright, housekeeping, want to make a motion again as ought to pass as amended?
Yes. I make the motion that HB 436 ought to pass as amended.
I'll second.
That motion has been seconded by Representative Welch. Wish to speak on your motion? Seeing no hands raised, no matter we put the question, the clerk will now call the roll. If you're in favor of ought to pass as amended, please say yea. If you are opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Burt,
Yes.
Representative Hopper,
Yes.
Representative Green, Representative Wallace,
Yes.
Representative Testerman.
Yep.
Representative True,
Nay.
Representative Pratt.
Yes.
Representative Doucette,
Yes.
clerk votes yes. Representative Harry Gathright,
Yes.
Representative Pantelakis,
Yes.
Representative O'Hearn,
Yes.
Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman.
The chair votes yes.
Mr. Chairman, the vote is 19 yea, 1 nay.
I vote 19 yeas and 1 nay. The motion of ought to pass as amended has passed. I'll move for consent. Representative Newman.
I withdraw the question. I just want to ask a question. Go ahead and do what we're doing. I don't have a question.
At this time, we will close the executive session on House Bill 438. Representative Gathright, will you be preparing the majority report?
Yes.
Thank you. At this time, we are opening the public hearing for House Bill 205 relative to incarceration under a suspended sentence. At this time, the chair recognizes Representative Shapiro to introduce House Bill 205.
Can you hear me?
Yes, we can hear you, Representative.
Thank you. Good afternoon, Mr. Chairman and honorable members of the Criminal Justice and Public Safety Committee. For the record, I am Representative Joe Shapiro, Cheshire 16, City of Keene. I come before you today to introduce House Bill 205, a bill relative to incarceration under a suspended sentence. This bill is identical to last year's HB 1611, although I will be proposing a minor amendment which you should have already received via email. Last year's HB 1611 was voted ought to pass in this committee by a vote of 20-0 and passed in the House by a voice vote. Unfortunately, it was one of the many bills that were placed on the table in the Senate due to COVID-19. HB 205 makes a small but important fix to a statute that allows residents serving as a sentence in state prison to petition for suspension of their sentence after serving 2/3 of their time. The amount of time served does not change. What does change is that instead of waiting to reach the 2/3 mark to be able to petition, residents will now be able to petition earlier, giving them the needed time to receive a court date, wait for that court date, and to enter and hopefully complete any needed rehabilitative programming related to their eligibility. Currently, residents must wait till they have served 2/3 of their sentence to petition, and if it is eventually approved, their release would occur well after the 2/3 time. You will see that the bill as introduced calls for an 18-month time frame, and the amendment reduces that time frame to 12 months to address concerns from the Department of Corrections. I believe that Commissioner Hanks or a representative from the department will be testifying in support of that shorter time frame. I want to take just a moment to give credit for this bill to the RCC, the Resident Communications Committee, a group of residents at the Concord Prison for Men whom I met with some 2 years ago. These men, many serving very long sentences, work with their fellow inmates to support a positive adjustment to prison life and work with corrections administrators to advocate for constructive policy changes. It was this very impressive group of men that identified this frustrating glitch and offered what I believe is a very helpful and very reasonable fix. Thank you, and I would be glad to take any questions.
Thank you, Representative. Seeing no hands raised, you are excused. The members of the public who wish to testify that are currently in attendance, please raise your hands at this time. At the discretion of the chair, we can limit testimony on House Bill 205 to 1 minute. And I recognize Ms. Mayo.
Good afternoon. I would like to thank the chairman as well as the committee for allowing me to speak. My name is Josiah Mayo. I'm a lifelong resident of New Hampshire and constituent. I am in support of House Bill 205. I believe passing this bill gives residents an opportunity to prepare for their eventual release. This is not a go home free pass. As we know, a judge still has to make a decision and the parole board still has to grant parole. We have heard testimony today that state's programming is contingent upon a resident's minimum parole date. Part of parole's release criteria is based upon residents completing programming. I would like to clarify what that means. An 18-year-old resident who has been sent to 3.5 years sentence would be forced to coexist with other residents who have been neglected or further criminalized due to the lack of timely programming and rehabilitation in one of the most extreme and deprived environments. This bill, in fact, helps residents, if eligible, to access programming sooner, which I believe is paramount to rehabilitation, successful reentry, as well as public safety. I support this bill for those reasons that I have stated. My hope is that this committee does as well. Take any questions you may have. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. Chair now recognizes Jay Mackey. Just a reminder, your testimony is limited to 1 minute.
Mr. Chairman, was that Matthew or Mackey?
Jay Mackey.
All right, thank you, Mr. Chairman.
Good afternoon, Chairman. Can everyone hear me?
Yes.
Great. Thank you for allowing me to testify on this bill. My name is Jay Mackey. I'm the Administrator of Classifications and Client Records for the New Hampshire Department of Corrections. As we were opposed to this bill with the 18-month time frame. The 12-month amendment is a more suitable time frame that we have seen, and we do support that amendment. As discussed earlier today with the House Bill 598, some of the issues arising is about getting into programs in a proper time frame. So when we do supply the court with all the needed information, we sometimes they do not have the ability to get into the programs because based on their minimum parole date, they were never able to get into the programs because getting their 2/3 is not something that is always granted. So we can't rely on that to get them into those programs. We usually get them into those programs around 2 years to their minimum. So that was an issue that was raised, but with the 12-month time frame, we do support this bill, and I can take any questions.
Thank you for your testimony. Representative True, you're recognized for a question.
Thank you, Mr. Chair, and thank you for taking my question. In your opinion, what makes the 12-month acceptable to you, but the 18-month not?
6 months.
So this bill allows someone that is sentenced to a 6-year minimum. Their 2/3 would be after 4 years. 18 months is about 2.5 years when they can apply. They've only served 2.5 years of a 6-year minimum. There's not really enough body of work that we would be able to supply for the court for them to make a good decision on whether or not this person should be granted 2/3. It also, an issue that arises is if that person is granted their 2/3 around 18 months to their minimum, what happens when they start, if they start committing major disciplinary violations at the prison? Most likely that falls on us to contact the county attorney to see if they would like to motion to impose the suspended portion of the sentence. We just think 18 months is too much of a time frame where they don't have enough programming to be completed that would allow them to be eligible for parole. And even if the court does grant their 2/3, they may not be able to be released on parole because they have not completed that programming as it is. Did I answer your question?
Yes, thank you.
Seeing no further hands raised, the witness is excused. Chair, I recognize Joseph Lascaz.
Thank you, Chair and members of this committee. My name is Joseph Lascaz. I will be representing the ACLU of New Hampshire and myself in full support of this legislation, HB 205, and I hope that this committee votes ought to pass on it as well. I myself have utilized the suspended sentence system when I was incarcerated. I have gone through it, and a successful reentry after incarceration requires preparation, hands down. A critical step in advancing public safety is reducing recidivism by making sure that people successfully reenter into their communities after incarceration. And reentry poses a host of challenges for incarcerated individuals, particularly for people who have been in prison for years or even decades, such as culture shock, identifying housing and employment, state identification needs that need to be renewed, just to name a few of the challenges. So it boils down to that a successful reentry that requires time. And HB 205 doesn't lessen accountability. Instead, it promotes responsibility. It incentivizes the decision to make a commitment to a positive lifestyle change and reentry. And it happens by promoting responsibility by causing residents to start to develop the necessary forethought and judgment skills to manage their own life and plan for their future, as well as incentivizing them to commit to making a lifestyle change. Because just because you are granted a suspended sentence, until you reach your parole date, that privilege could be withdrawn at the request of the DOC.
Your time has expired, so I do have to ask you to conclude your testimony.
Sure. This bill doesn't guarantee that anyone's going to go home. All it does is allow people to prepare for an eventuality, which is what we're looking for in a successful reentry.
Thank you again for your testimony. Seeing no hands raised, the witness is excused. At this time, the chair recognizes Donna Brown. Just a reminder, testimony is limited to 1 minute.
Thank you. This is Attorney Donna Brown. I am representing the New Hampshire Association of Criminal Defense Lawyers. And I won't repeat, I agree, we are in favor of this bill, and I agree with everything that's been said before. As a lawyer who regularly does these bills, does these motions, I just wanted to add a couple of things that also add on to the time. I agree in terms of getting people into programming. Once you file this motion, and some very times I've filed it the day it's been allowed, so we try to get them filed as soon as possible. Then the other side has 30 days to respond. So now everything comes to a grinding halt for the response. And then there's something called a synopsis that the Department of Corrections writes, which is basically a summary of the inmate that goes to the judge. That takes time too, and it can't be done ahead of time. So there's these things like the reply from the prosecution and the synopsis that hold things up. So it's not you just file the motion and then the judge decides. Many times it can take 4 or 5 months after someone's eligible before they actually get their day in court or get a ruling. And I'll limit my testimony at that point.
Thank you again for your testimony. Seeing no hands raised, the witness is excused. Chair now recognizes Evan Pineda.
Thank you, Chair. My name is Evan Pineda. I'm in support of, I'm sorry, I keep forgetting the bill's numbers, but I'm in support of this bill. I also was formerly incarcerated. I am a resident of Nashua, New Hampshire. I'm representing myself. HB 205. I'm in support of HB 205. I personally went through the prison system. I also had filed for 65120 to amend my sentence. And I fully understand that, no one is ever able to fully realize the full power of this bill of 65120 because you're not eligible until you've reached 2/3 of your sentence. So right off the rip, you're not able to fully enjoy that if you're granted that by the court. I'm sorry. So I'm full support. Giving a year out gives plenty of time of preparation. I personally, it took me a year before I actually filed past my 2/3 point because I was trying to get all my ducks in a row. And I was also trying to go through the DOC to get a letter of recommendation from the Commissioner Run at that time. And I was successful, at least as I'm getting some time, a portion of that time granted me 2 years. But again, I just want to say that support it. I know time is limited, and it would be beneficial to the inmates and to the staff on the inside to get the process going. It is a long, drawn-out process. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. If there's any members of the public who wish to testify that have not testified already, please raise your hand. Seeing no additional hands raised.
Mr. Chairman?
Yes.
Donald Brown.
I believe Donna Brown's already testified.
Oh, I'm sorry. Thank you, Mr. Chairman.
Is that the same Donna Brown from before?
I did not recognize the name. I apologize.
Mr. Chairman, my apologies that she did testify. I was looking to make sure.
Seeing no additional hands raised, at this time we'll conclude the public hearing on House Bill 205.
And the sign-ins on House Bill 205, we had 63 people sign in support and 5 people sign in opposition.
Thank you, Representative Muse. At this time, we're going to reopen the executive session on House Bill 238. Representative Berger, would you recognize?
Yes, Mr. Chairman, I would like to be recognized to reconsider House Bill 238.
Representative Tru?
Second.
That motion for reconsideration has been seconded. Representative Burke, do you wish to speak to your motion?
No.
Before we put that question forward, let me just address a few issues. Move this along quickly. First, if any member wishes to object to any ruling of the chair of procedure, it's appropriate for that member to raise a point of order, especially if there's any question on whether the parliamentary procedure is being followed. Now, it is difficult when multiple members are doing that at once, whether they're in the room or participating remotely, especially what makes it difficult is multiple voices are coming through the same microphone or speaker at the same time. So, and it was apparently a point of order was raised by a member in this room that I could not even hear. That's how loud it was. So I would ask that if there is any questions of the rules, that we try to conduct ourselves in accordance with the parliamentary rules. Simply, if a rule is not being followed does not mean we violate or fail to follow additional rules. Now, when it matters, put the question is put forward. That means we are now in the voting mode. If a member is not in their seat at the time the question is put, that member is not allowed to then take their seat if they're not already in it. The rule also prevents that member from leaving the seat while we're in the voting mode. So I understand that if your video cameras are on or off, if you're off, I have no idea if someone's in the seat. But if the camera's on, I see an empty chair, or if the person's physically present in the room, and when the question is put, if you're not in your chair in this room, you are now not allowed to take your seat. And that's House Rule 107, if anyone is interested in referring to. So, in respect to the motion to retain, when there was a member not in their seat, it was my understanding and ruling, because that member was not in their seat when the question was put, that member would not be permitted to take this. So when the roll was called, apparently that member's name was not called, which it should have been called. So for a housekeeping matter, to make sure we're doing our best we can to follow the parliamentary rules the best that we can, I hope that this reconsideration is allowed so we can re-vote on the question. And I would just ask going forward, if there is any questions of the chair, that we try to do our best to keep it calm, because I think there was a lot of things were missed during the chaos. With that being said, I would like to put the question, move the question. Seeing no hands raised, the matter we put the question, the clerk will call the roll. If you're in favor of the motion for reconsideration, please say yay. If you are opposed, please say nay. I ask the members at home to please turn on the cameras.
Vice Chairman Welch,
Aye.
Representative Burke,
Yes.
Representative Hopper,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative Tru,
Yay.
Representative Pratt,
Yes.
Representative Doucette.
Yes.
The clerk votes yes. Representative Harry Gathright.
Yes.
Representative Pantelakis.
Yes.
Representative O'Hearn.
Yes.
Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley.
Yes.
Chairman.
The chair votes yes.
Mr. Chairman, the vote is 21.
By a vote of 21 nays, 0 nays, the motion for reconsideration is passed. This time, the chair is recognizing Representative Welch to make a motion.
I move that we retain House Bill 238.
Representative Wallace,
Second.
the motion to retain has been seconded. Seeing no hands raised, the matter is put to Question, the clerk will now call the roll. If you were in favor to retain, Representative Boydell, we're in the voting mode. If you're in favor of the motion to retain, please say yay. If you are opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Burke,
Yes.
Representative Hopper,
Yep.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt.
Yes.
Representative Doucette.
Yes.
The clerk votes yes. Representative Harry Gathright.
No.
Representative Pantelakis.
No.
Representative O'Hearn.
No.
Representative Bourdonnais.
No.
Representative Muse.
No.
Representative Newman.
No.
Representative Bolden.
No.
Representative Conley.
No.
Representative Knight.
No.
Representative Bradley.
No.
Chairman Abbas.
Chair votes yes.
The vote is 11 to 10.
By a vote of 11 yeas and 10 nays, the motion to retain is allowed. This time we will close the executive session, House Bill 238. Representative Pantelakis, you recognize?
Yes, will we have a work session on that bill?
We can. To tell you when that will happen, I couldn't even guess. But I think that would be helpful to the committee.
I think that if you're gonna retain a bill, that you would intend to hold hearings on it in the fall.
Oh, of course. I just don't want to say this. I'm not sure what the summertime's going to bring as well as the fall. I don't want to make any representations that will confuse the members or the public.
Thank you.
Try to avoid making it. But hopefully times return to normal. This time, we were going to open the executive session on House Bill 138, allowing prisoners serving a life sentence to be eligible for parole for 25 years. Chair now recognizes Representative Rhodes to make a motion.
Mr. Chairman, I make the motion to ITL House Bill 138.
Is there a second?
I'll second.
And second by Representative Wallace. I'll take this to see the motion.
Yes, actually, we heard a lot of testimony today. Obviously, what I'm hearing a lot of is the person that is in jail and or medical expenses. And it actually is very sad to me that we're hearing everybody talking about that, but nobody talking about the victim or the family of the reason why the person is in prison. And I think that should be taken way more into consideration than it was personally, and I think it's an idea.
Thank you, Representative Rose. The matter will now be open for discussion. Representative Conley.
Thank you, Mr. Chairman. Co-sponsor of this bill. Well, first I'll say I'm going to be leaving as soon as I finish speaking because I have an important work call. The timing is problematic, but that's what we do. I supported the concept of this, despite struggling with the impact on victims and the fact that people do very bad things. And some people who do very bad things should never be let out of prison. That said, testimony today from a number of people made me question my decision to co-sponsor this bill. So if I'm present in the room, I will be voting for ITL.
Thank you, Representative. Representative Borjak, you're recognized.
Thank you, Mr. Chair. I will not be voting for ITL. I think that this is a good bill. In 25 years, people have opportunity to rethink of about what they've done, to mature. We know that the aging process changes people's hormone levels. And I think that after 25 years, if a person is still behaving well, then they should have an opportunity to have a parole review. Thank you.
Thank you, Representative Borjak. Representative Newman.
Thank you, Mr. Chair, for taking. Thank you, Mr. Chairman. I also will be voting for this bill because I also believe that after 25 years and based on the testimony we heard from the parole people today, that they take into consideration the possibility of the dangerousness of the person and how they've reacted over those 25 years. And I think that if it's one of those people that has not rehabilitated at all and is truly a dangerous person, they won't get parole. But I think there's a significant number of prisoners that may have rehabilitated. As a matter of fact, I got a letter from one of them that where there were multiple degrees that were earned and multiple ways that they had helped other prisoners to be rehabilitated. And I think that they should at least have the ability to have a hearing on a parole. So I'll be voting for this bill. Thank you.
Thank you, Representative. Representative Bolden.
Thank you, Mr. Chairman. I'm going to be opposing the ITL as well. I know that the state constitution dictates that punishments should be designed to reform and not to punish. And I believe that if we have any confidence in our prison system at all, we should have confidence that it's possible for anyone to be reformed during their stay. So for that reason, I'm going to oppose the ITL. Thank you.
Representative Hopper.
Thank you, Mr. Chair. I think when the Constitution was written, there were certain crimes that people did where they executed them after they did the crimes, after their trial. So there was no need, they were not reformable because they were dead. Would you believe that?
No. Seeing no further hands raised, the matter will be put to question. The clerk will now call the roll. If you're in favor of the motion of any scheme to legislate, please say yes. If you are opposed, please say no.
Vice Chairman Welch,
Aye.
Representative Burke,
Yes.
Representative Hopper,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yes.
Representative Pratt,
Yes.
Representative Doucette.
Yes.
The clerk votes yes. Representative Harry Gaffray,
No.
Representative Pantelakis,
No.
Representative O'Hearn,
Yes.
Representative Bourdonnais,
No.
Representative Muse,
No.
Representative Newman,
You're muted.
Representative Newman.
No.
Guess he didn't want to vote.
Representative Bolden,
No.
Representative Conley, Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman Evans.
The chair votes yes.
Mr. Chairman, the vote is 12 to 8. 12 yea, 8.
By a vote of 12 yeas and 8 nays, the motion being legislated has passed. At this time, we will close the executive session on House Bill 138. At this time, we are opening the public hearing on House Bill 443 relative to an extended term of imprisonment for assaulting military personnel. Who is recognizing Representative Edwards, I believe, to introduce House Bill 443.
Thank you, Mr. Chairman. This is Representative Edwards. I'm not here to introduce the bill. I'm here to testify on it. Maybe the bill sponsor is here.
My mistake, Representative Edwards.
That's all right.
$443. That's my apology.
Hello?
Yes. Good afternoon.
Hi, yes, this is Representative Mike Boards. I'm the one that introduced this bill. This was pushed on me by actually a constituent of mine when I was out door knocking. Because he was discussing with me issues where military personnel while in uniform have been spat on, assaulted, called all sorts of names, attacked, and so on. So just like we have for police officers and first responders, he wanted me to push this by adding veterans and military personnel to this bill.
Thank you, Representative. Representative Pantelakis, you're recognized.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. Would this mean for just in uniform only?
That was my intent. I don't think that's the way it was actually, it wasn't specific in the actual bill, but that was my intent, yes.
Thank you.
Seeing no hands raised, I want to thank the representative for his testimony.
Thank you.
Yeah, the chair now recognizes Representative Edwards.
Thank you, Mr. Chairman. I'm Representative Jess Edwards, representing Auburn, Chester, and Sandown. I'm a retired Army Lieutenant Colonel. Since 9/11, I deployed out of the Army National Guard and the Army Reserves on 2 separate deployments. And what I think when I see this bill is the concerns I had when I was in Afghanistan, and we were reading intel reports saying that there were domestic terrorism plots that were targeting the families of deployed soldiers back home. And the way I think my compatriots and I thought about that was that we knew what we were accepting. We knew what risks we were accepting, and we were there as a team, trained, equipped, and all of that. But fortunately, this domestic terrorism didn't occur that I know of. But I would almost rather have this apply to the member of a military armed forces family more so, because the threat of domestic terrorism striking at a soldier's family while they're deployed is a much more harmful thing to society and our ability to defend the nation. I'm not opposed to having soldiers also protected by this, but my bigger concern would be protecting families because that can undermine morale far more than having one of your fellow soldiers be struck. So that's my testimony. If you have any questions, I take questions.
Thank you, Representative, for your testimony. Seeing no hands raised, Representative York. At this time, if there's any members of the public who wish to testify that have not testified already, please raise your hand. The chair now recognizes Kevin Grady.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, for the record, my name is Kevin Grady, and I'm a 22-year resident of Hooksett following a 25-year career in our Air Force. Today, I'm here representing the State Veterans Advisory Committee, and for the benefit of those members of the committee who might be new or unfamiliar with what we do, we're chartered by State RSA 110 to speak for the veteran community in New Hampshire. And we have 20 members as of last night when we added the 20th member. And these are names of organizations that are probably familiar to you. Things like the American Legion, the Veterans of Foreign Wars, the Military Order of the Purple Heart, organizations like that. One of the things that we do is we take a look at all the bills coming before the Senate and House, and we pick out the ones that we think have a veteran impact, and then we discuss those bills and we come up with a position, and then they send me to testify to you and tell you what it is that we think. And so I'm here to do that today, but I'm also here to offer our services. If you're intending to write a bill that you think it affects veterans, we're a resource that you can use to help make sure that the bill says what you want it to say and does what you want it to do. Our members unanimously support this bill. To be honest, most of them did not know that there was, in fact, an increased penalty in 651 for these other folks like firefighters and other first responders and police officers. And we feel like we perhaps belong in that group as well. And I think it's even more needed now if you take a look at the visibility of our Guard members. Our Guard members are out there every single day manning all the vaccination sites in the state and doing yeoman's work. And so we do support this bill, and subject to your questions, sir, that's all I wanted to say.
Thank you for your testimony. Seeing no hand raised, the witness is excused. Is there any members of the public who wish to testify that have not testified already? Please raise your hand. Seeing no further hands raised, this time we'll close the public hearing on House Bill 443.
The sign-ins on House Bill 443, there was one person who signed in supporting the bill and 5 people who signed in opposition.
Thank you, Representative Hughes. I did receive a few questions electronically. Just so the members of the public know and the members participating remotely, both Representative Wallace and Representative Bissett are physically in the room, so the issue of them turning their cameras on during any votes would not apply because they're in the room. So, just to clarify that. This time we will open the executive session on House Bill 598 relative to the portion of a minimum sentence to be served to be eligible for parole.
I'd like to make a motion.
Representative Burke to make a motion.
Thank you, Mr. Chairman. I'll make a motion of ITL.
Is that second by Representative Wallace?
Seconded.
Representative Burke, do you wish to speak on your motion?
Yes, Mr. Chairman. Just hearing the testimony, it sounds like, there are exemptions that especially because of the emails I got, they talked a lot about the elderly. That there is, about their medical conditions. And there was a gentleman I think he was from the prison that spoke on that and said, I asked him the question and he said that you can get a medical exemption to have a parole hearing. The kid there from Nashua, even though he was supporting the bill, he just gave a lot of information. It was almost like he was against the bill because he was saying how wonderful the programs that he took and how it reduced his sentencing. So I just look at this bill that it's not really needed. I think that, the system is working and I think we should go with that. Thank you, Mr. Chairman.
Representative Gafford?
I did say I had a motion, but I think you didn't hear me. But with that said, I'm going to vote against the ITL. And if you keep, not just people refer to the medical issue on 598. At no point the medical was discussed on 598. The medical was discussed on 138. So just let you know. What was important was the fact that we're the only one at 100%. And that's truly important. The other factor that came out in the middle of 598 was the fact that if you wanted to get earned credits, you had to be able to afford to pay for it. And if you were not able to pay for it, you couldn't get earned credits. The other factor that came out that for one of the other things that they had, you go back before the judge. This says you go back before the board that tells you and gets information from the DOC as to what type of person you've been in your term or what you've done to, rehabilitate yourself. That's entirely different from 138. So I definitely would vote against this because I definitely feel that this is a good bill. If my colleagues had a problem with the 50% where many states have 50%, some states have done away with truth in sentencing. And the other factor is last term, when it was suggested that we have a committee, it was Donna Sitek that came and voted against that, even though the DOC had recommended it. So my point of the matter is that, either you're for it or you're not, whether you're in a committee or you're not in a committee. But it's definitely a darn good bill.
Representative Clark, I know your hand was raised. You wish to be recognized?
No.
Representative True?
Thank you, Mr. Chair. I cannot support the bill because I find the bill to be far too broad in its reach. Well, it wouldn't make any difference if a person were in prison for DWI in which you hurt nobody but yourself, or you're in prison for murder. You get a 50% reduction, and that's different crimes should be treated in different ways, and I can't support this bill, it's too broad. Thank you, Mr. Chair.
Representative, let me recognize Representative Muse first.
Okay.
Representative Muse?
Thank you, Mr. Chairman. Hearing this bill was really an educational experience. I think every time we hear one of these bills, it's an educational experience for all of us. I know as a first termer the last time, it was semi-overwhelming trying to take in all of the information and the points that are made. I sympathize with those folks who are here with us for the first time. While I'm sympathetic to the concerns that are raised or that were raised by the parole board, and while I'm always extremely sympathetic to the families of victims, I think the fact remains that taking away a person's freedom in this state is the worst thing you can do to somebody. And I think when you do that, the standard, not only to send people to prison, but to keep them there has to be very high. And when I look at the fact that so many other states have moved off of this law, other states I think the original federal law, we heard testimony, was 85% for truth in sentencing. New Hampshire is the only state that's at 100%, and most of the other states are far, far below that. And I ask myself why. And I think a lot of it comes back to the fact that we do not properly invest in the parole process and in the parole board. They operate on shoestring resources, and I think one way to look at that is that definitely saves us some money. But one of the other things it does is it creates resource constraints that make it very, very difficult for people who know how much work they'd be facing if we passed a bill like this to go ahead and pass it. And when I ask myself, what do I weigh more heavily? Is it keeping a broken system limping along? Is that the thing that's most important to me? Or is it making sure that somebody who deserves a chance at freedom, or who maybe has earned a chance, giving them just the right to have a review? And so I'll be voting against the ITL. My guess is this issue is going to be one of those issues that keeps coming back to us, not only in other bills this session, but in bills in other sessions. And I would just urge everybody, I wish I would have prepared a little bit better for this today, because this is an issue that really deserves any and all attention that we can put into it, because this really does affect the lives of the people who are in prison. It affects the lives of their families at home. It affects us and our entire criminal justice system. So thank you.
Thank you, Representative. Representative Cashman, you recognize?
Thank you. I have 2 points. I received a letter from a prisoner on this opposing it. But the letter, and granted, you know, I have no background on him other than what was in his letter. It wasn't very sympathetic when you really stripped it away, because he wasn't like the people who testified, who were former prisoners. You know, he clearly was not accepting, you know, his part in being incarcerated. He was merely complaining about how bad the system was. So, you know, I think we need to be very careful with the people who testify, because they're people who have learned how it works, and you know, they present a good face. The other thing is, I heard today about, and these kinds of laws sort of drive how many people we have in prison. And the impression that you get is that New Hampshire is imprisoning more people than we really ought to, more people probably than any other state, and so on. And that's just not true. I looked up the statistics on the incarceration by state. Out of 50 states, we're in the bottom 5 of those. And there's a group of them that are just sort of plus or minus a few different. But we don't incarcerate that many people. That tells me that I don't care really what other states are doing, but yeah, I think maybe we're doing the right thing about the balance of who we keep and who we let go. So I'll be voting against this.
Thank you, Representative Desmond. Representative Crowley.
Thank you, Mr. Chairman. A couple things stood out from that testimony earlier today. One was a comment that hard cases make bad laws. That was in reference, as I understand it, to a very awful homicide and a miscarriage of justice relative to the sentencing. That changed New Hampshire's basically our sentencing structure for every other criminal that is then sentenced in the future. Another thing that stood out is after that change, sentencing itself did not reflect the new truth in sentencing. So, which is what former Speaker Sitek indicated. So, the result of that was a tenfold increase in the number of people serving prison sentences in our state, from around 200 to around 2,000 now. It's nice to know that it's declining slowly, but this bill makes a uniform approach to addressing a prior wrong. We heard about programs in the system that determine when somebody could be eligible for parole. That system can adjust to this new standard. And lastly, I'd say that this is not saying somebody will be paroled. It will say they are eligible for a hearing. Those are two very different things. These are ways to sort of speed up somebody's rehabilitation. It's a good bill and we should pass it. Thank you.
Representative Pauling. Representative Pantelakis.
Yes, thank you, Mr. Chairman. In 2004, Representative Welch appointed me to do a study on the prison system. And we were at 264 people in 1984. In 2004, we were at 2,600. And the truth in sentencing law needs to be looked into, and we need to change it. Maybe this bill won't do it, but everybody better think about that. I hear everybody, all these cuts being made, but the prison is still people are gonna have to be fed and clothed and whatnot. We need to look into that. Thank you.
Representative Newman.
Thank you, Mr. Chair. I will be opposing the ITL on this bill. I also think that it's a good bill and serves its purpose. I also thought I heard a comment that we ought to be careful about people that testify, and I am completely confused by that statement if it was said. Thank you.
Yes.
Representative Bourdonnais.
Thank you, Mr. Chair. After a lot of thinking about this bill, I'm going to support the ITO, but I think that what we should think about doing in the near future is adjusting the sentences that we are now have put in our system, and that would address some of the issues of how many people we are imprisoning, and so I'm willing to do that at a later date. Thank you.
Representative Gafford.
Yes, I just want to say again that even at half your sentences, it doesn't say that you're going to be paroled. So if we believe that our parole folks are honest, upfront, and doing their job, they're not going to just let anyone go. This is an opportunity for a person that could possibly be eligible because they've done their programming, they've done whatever's necessary to rehabilitate, to have that opportunity to go before the parole board. But again, those on the parole board are the ones that make the decision. So I'm asking my teammates to vote against the ITL.
Representative Rhodes.
Thank you, Mr. Chairman. I have a question that might be, you might be able to answer this, but it goes also along the lines of what Representative Bourdonnais was saying. There appears to be a lot of not in this particular bill, and as far as where it starts is the question I have. Would this apply for future sentences, or does this almost look at everybody that is now in prison? Like how far back would it go?
My interpretation of the bill as drafted is it would apply to all sentences, including people who are currently incarcerated, as well as people that are incarcerated in the future.
That's right. And it's 60 days, I'm sorry. It's 60 days actually.
If you say 60 days, they come
To become law.
But for everybody that's in, I'm sorry.
You're right, man. So if someone's already in prison right now, serving a sentence, and let's say they serve 60% of their minimum sentence already, and the minimum sentence 5 years, they would be eligible to 2.5 years. And even if they serve 3 years, that means they would be eligible for immediately.
Okay, thank you.
So I just want to, you guys use the term eligible for parole, which I noticed that when I had gone to them, I had put something different, but they did put eligible. But for me, I don't look at it that way. I think that it gives them the opportunity to go before parole board. Just that simple. It's an opportunity to go before the parole board. And I believe that the parole board would make the right decisions.
Seeing no hands raised, the matter will be put to question. The clerk will now call the roll. If you are in support of the motion of speaking to legislate, please say yay. If you're opposed, please say nay. I ask that the representatives who are not physically present in the room, please turn on their camera to their devices at this time.
Vice Chairman Welch,
Aye.
Representative Burke,
Yes.
Representative Hopper,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Doucette,
Yes.
Clerk votes yes. Representative Harriet Gaffray,
No.
Representative Campbell-Office,
No,
Representative O'Hearn,
No.
Representative Bourdonnais,
Change my mind, no.
Representative Muse,
No.
Representative Newman,
No.
Representative Golden,
No.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman.
Chair votes yes.
Mr. Chairman, the vote is 11 yea, 10 nay.
By a vote of 11 yeas, and the motion for the legislature passes. Will there be a majority report?
Yes, Mr. Chairman.
Thank you. Will there be a minority report?
Yes. Yes.
Thank you. This time we will close the executive session on House Bill 598. This time we are opening the public hearing on House Bill 576 relative to Victims Compensation Fund. Your representative who signed up to introduce the bill.
Chairman, I do not see the prime sponsor.
Yes,
Oh, she is. Okay, thank you, Mr. Chairman.
I am here.
Representative Massanilla, you are recognized to introduce.
Thank you, Mr. Chairman, and ladies and gentlemen of the Criminal Justice Committee. I'm Linda Massamiller. I represent the towns of Littleton and Bethlehem. I'm here today to introduce House Bill 576, which came before the Criminal Justice Committee last year as House Bill 1263, where it was recommended ought to pass by an 18-2 vote, then went on to the House calendar and finally moved to the Senate, where it was later tabled because of COVID-19. Excuse me. House Bill 576 would amend the provision of the state's Victims Compensation Fund to allow claims by victims of child human trafficking or sexual abuse to be filed at any time. The nature of sex trafficking is unique due to the common trauma bonding that occurs between the victim and the offender. Because of this bond, it is common for survivors of trafficking to not recognize their own victimization until they've received comprehensive care and services. This realization could happen anytime after victimization and is also compounded by the fact that in the sex trafficking context, many older youth and adult victims who were trafficked as minors are still regularly identified as prostitutes or consensual sex workers, not victims of a crime. By removing the filing deadline, acknowledgement is made that the recognition of victimization and obtaining enough stability to file for compensation can happen many years after exploitation ceases, and that the victims are still deserving and needing of compensation if they choose to address long-lasting physical, psychological, and emotional harm that has been endured. This bill would also eliminate the filing deadline for child victims of sexual abuse or who were victims of familial sex trafficking. House Bill 576 would also remove the contributory fault consideration for compensation relative to children of trafficking or sexual abuse. The committing of criminal offenses is an inherent element of sex trafficking victimization. Trafficking victims do not engage in commercial sex or unlawful practices by choice, but are coerced by either fraud, deceit, or survival. As such, to suggest that human trafficking survivors may contribute to their own victimization would appear unjust considering their circumstances. I know that last year concerns arose around the possibility that excessive claims would be generated if the 2-year deadline was removed. I checked with the Department of Justice, and in 2020, the compensation program reported that of 425 applications for compensation that were approved, 33 were child sexual assault claims, and there were no claims related to human trafficking. In conclusion, New Hampshire's taken giant steps in the area of human trafficking by including child victims of sex trafficking under the definition of abused and allowing the vacating of nonviolent crimes committed by minors being trafficked for sex. HB 576 provides these victims of sexual abuse or trafficking the right to access some form of compensation long after the egregious crime was perpetrated against them. Thank you for listening.
Thank you, Representative, for your testimony.
Thank you.
And Representative, if you don't mind, the chair may inquire of a question. You mentioned this is identical to a House bill from the previous term. Do you mind repeating what that House bill was?
HB 1263.
Thank you, Representative.
Thank you.
Do you know, is there a reason why there's not a fiscal note attached to this bill?
I don't.
Thank you.
I do know that there is someone here from the Victims Compensation Fund who can answer any questions you might have that would have to do with the monetary part, possibly.
Thank you. Representative Ward.
Yes, Mr. Chairman, I can guess why there's no physical note, because the money is not going against the general budget. It's coming from an established fund.
Thank you. Thank you.
Seeing no further hands raised, the witness is excused. Thank you again for your testimony.
And thank you.
If there are any members of the public who wish to testify that are in attendance, please raise their hands at this time. The chair is recognizing Ellen Cobb, and at the chair's discretion, we're going to limit testimony to 90 seconds.
Thank you, Mr. Chairman, members of the committee. My name is Ellen Kolb, and I'm a resident of Merrimack, New Hampshire. And I'm very happy to come here today and join Representative Massimilla in asking you to please support House Bill 576. I was one of many people last year, part of a very broad coalition that supported the equivalent bill, HB 1263, which those of you who were on the committee may recall passed overwhelmingly out of committee and was passed on a voice vote by the full House before, along with many other measures, it was derailed by COVID. I'm glad that it's back. I'm glad Representative Massimilla is still leading on this, and I ask you, please listen to her and pass this bill. I think it is good legislation and good policy. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. The chair recognizes Jasmine Fiandaga.
What's the last name, Mr. Chairman?
Fiandaga, F-I-A-N-D-A-C-A.
I'm not seeing the name.
Yeah, she signed up.
Jasmine, Marino. Oh,
Marino.
yep, is that the one?
Mm-hmm.
Oh, that's her.
Hi, can you hear me?
Yes, we can hear you.
Okay. Yeah, I'm a survivor of commercial sex trafficking. I go by Jasmine Grace Marino for my work, but my married name is Fiandaga. Sorry for the confusion.
Your testimony is limited to 90 seconds.
Okay, so thank you for having me, Mr. Chairman and ladies and gentlemen of the committee. Like I said, my name is Jasmine Grace. I'm a survivor of the commercial sex trade. I've been out of sex trafficking and clean and sober for 13 years. I want to say that the experience is very traumatizing, and it took over 10 years for me to tell anyone what happened to me. And I believe that time should not be a factor to apply for victims' compensation, because many victims like me don't tell anyone, because sometimes we don't even know that there is any help available, or because we're so ashamed we don't talk about it. I personally had no idea there was victims' compensation funding, and there is very limited funds available. And it's such a small amount that the opponents will probably testify against the bill on that presence. So even a small amount of financial help might make the difference between getting some counseling or clothing for a job, so we're able to restart our lives and move forward. So please ought to pass on HB 576 and remove time as a limitation from victims' compensation funding. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. At this time, the chair recognizes Maria Perez.
I've asked her to unmute Mr. Oh, there she is, Mr. Chairman.
Thank you, Mr. Chairman. I'm a State Representative Maria Perez. I represent District 23, but today I speaking on behalf of myself. I'm probably gonna take more than 2 minutes because I respect if you told me to like stop with my testimony in 2 minutes, but I just want to share my personal story. I'm a victim of sexual assault. I was raped by my own father, but that's not the whole story. So when I was 15 years old, I met my ex-husband, who was 47 years old when I met him. I was only 15 years old. But for me, my story to survive started when I was 15 and I met him. He promised me to bring me to the US, and he promised me to better life after being abused since I was 5 years old. He was a US citizen. He traveled back to the US. He sent me with some people to travel to the US. When I was going through Guatemala and Mexico, I was abused. I was sexually assaulted by a couple of people that I don't even know who they are. And then the last time I was abused by these people, it was when I got to California. That was 33 years ago. I believe victims, they should have the right, even though after 30 years or 10 years or whatever, they should have the ability to ask for help. It is hard for me to speak about this, and I'm proud to be a US citizen. I'm proud of like everything that I accomplished. I graduated from college when I was 42 years old. I went through domestic violence. I went through sexual abuse. But to be honest, I'm proud to be who I am right now, and proud who the person that I come. But without the help of all these organizations and without all the support that I got, I don't think I would have made it this far. And be able to help other victims, that's what I have the courage to be talking to you and to be sharing my story. It's not easy, but I think sharing my story is going to help other victims. And then it's going to help you to understand that victims, they need help even after 2 years or 10 years. Thank you.
Thank you, Representative Perez, for your testimony. Seeing no hands raised, Representative, you're excused. This on the chair recognizing forgive me, I'm not going to pretend to pronounce it. I'll just.
Nicole is unmuted.
Good afternoon, Chairman and members of the committee. Can you all hear me just fine?
Yes, we can hear you.
Okay. My name is Nicole Kippett, and I am the Administrator of the Victim Services Unit with the New Hampshire Department of Corrections. I am here in support of House Bill 576. I did submit my written testimony yesterday. As an advocate working for the Victim Services Unit, part of our job is to assist victims by referring them to or submitting applications for financial assistance through the Victims' Compensation Fund. In fiscal year 2020, the Victim Services Unit assisted 7 victims with victims' compensation applications, and so far in fiscal year 2021, we have assisted 8 victims with applications. Of all of the applications we have assisted, thus far, 5 individuals are survivors of sexual assault and beyond the 2-year timeframe outlined in the current statute. Although the number of individuals that we assist with these compensation claims seems small, the impact that the financial assistance can have on an individual victim and his or her family can be astronomical, as it removes some of the financial barriers for victims as they take steps forward in their unique healing process. In cases where advocates are working with victims to submit applications for victims' compensation, the reason for application most often centers around the victim's desire and need to re-engage in trauma-informed therapy, relocate for safety purposes, or for victim offender dialogue expenses. Without the financial assistance provided by the compensation fund, many of these victims may go years without the support or therapy necessary to continue to move forward towards full healing, or may continue to live in fear due to the inability to relocate. Within the past week, I personally have worked with a survivor of childhood sexual assault who has been consistently harassed by her perpetrator through phone calls, letters, and by third-party family contact, even though the offender has remained incarcerated. Due to the harassment and the reality of the offender's eventual release into the community, the victim is seeking financial assistance through the compensation program to relocate to a new area where the offender will be unaware of her location, and she can feel safe and free from the harassment and intimidation she has experienced. But due to her current financial constraints and the expenses related to relocating, without the assistance of the victim's compensation funding, this victim may not be able to relocate and will continue to be harassed by the offender and his extended family. House Bill 5.
You do have to limit testimony to 90 seconds.
Sure, that's it. Thank you for your time. I'm open to any questions you may have.
Thank you again for your testimony. Seeing no hands raised, witness is excused.
Thank you.
This time the chair recognizes Bob Dunn. Mr. Lamine,
Mr. Chair, members of the committee, I'm Bob Dunn, the Director of Public Policy for the Roman Catholic Diocese of Manchester. And I'm here today to register our support for House Bill 576. I just said this to the committee, I'm sure, a couple of weeks ago on House Bill 180, but the Catholic Church worldwide sees human trafficking as, to use the words of Pope Francis, nothing less than, as he says, one of the great evils of our age. And I think in looking at a bill like this, it's important to think about escaping from human trafficking as something that involves not just the first minutes of that event, but it also involves the ensuing months and years as well. So bills like this obviously help trafficking victims in that indispensable effort of forging a new post-trafficking life. So I want to say thank you to Representative Massimilla for bringing this forward, and thank this committee for all of its work on this issue this year and in prior years. Thank you.
Thank you, Mr. Dunn, for your testimony. Seeing no hands raised, witness is excused. If there's any members of the public who wish to testify that have not testified already, please raise your hand. Seeing no hands raised, this time we will now close the public hearing on House Bill 576.
And Mr. Chair, sign-ins on this bill, HB 576, there were 36 people signing in support of the bill, 0 people in opposition, and 1 person signed in neutral.
Thank you, Representative Muse. The Criminal Justice Public Safety Committee will be in recess at 2:55 p.m.
I
don't know. I never know where the back's coming from.
That's been shared a lot.
Oh, Fred, did you see,
Representative Conley,
Yes, sir.
for someone who works full time just like you, if you do have a work matter, no recognition to vote on your bills while you're on work calls. But I could not have timed that any.
Worse.
Depends what I was trying to accomplish, but the timing of that could not have.
I appreciate that. Thank you. I just to let you know.
this is Daryl and his wife going for a walk in the
I
woods?
assumed that was ITL.
This is her. She's not. No.
Representative Rhodes,
Yes,
can you tell me what the vote was on 138?
certainly. I wasn't able to keep track on here today because, well, it is today.
Yeah.
12-8.
12-8. Thank you.
Don't leave me. I mean, I thought we were just becoming friends and you walk away.
Representative Wallace.
138 was it?
Representative Wallace.
These are late.
12-8.
Potato chips, aren't they?
Well, you just don't want to end up on my laptop.
These are late.
Okay, I just.
Oh, so I gotta get up and move.
Yeah. No,
All right, boys.
Right, we can sneak one in, guys. Can the members at home hear us?
Yes.
We are gonna, in about 1 minute, we're gonna open the executive session on 4:43.
4-3.
443.
I don't have 443 ready for the day. I don't know how, but I don't. So give me 1 second. So I'm not. I missed it.
Good afternoon. At this time, we are opening the executive session on House Bill 443. Chair is recognized Representative True to make a motion.
Thank you, Mr. Chair. Mr. Chair, I move House Bill 443 is inexpedient to legislate.
And Mr. Chairman, I'll second it if you don't mind.
Representative Burr, you've been recognized to second that motion. Representative True, do you wish to speak on your motion on inexpedient to legislate?
Thank you, Mr. Chair. This is, again, an overly broad bill that says that extends protection to military personnel. However, if you were in a bar somewhere and got into a fight with a man or a woman, and then found out afterwards that they were in the military, this law applies to you, and you had no idea they were in the military. That is a major fault I find in the bill. Right? The major fault I find in the bill is because I do not favor making lists. I do not favor making lists that says some people are more worthy of protection under the law. I believe we should always go with equal protection under the law, and that's why I move ITL. Thank you, Mr. Chair.
Who seconded that? Was it Bert?
Yes.
Second, Representative. Thank you, Representative True. And I appreciate the comments. And really, I think it's important, even if the actor knew the person was a member of the armed services, that person may not be active at the time. And it's that special class that you're referring to would still be implicated even when the person's not active duty. And I think I would believe that would be problematic to elevate the penalty for such a circumstance as well. Seeing no further hands raised, the matter will be put to question. The clerk will call the roll. If you're in favor of the motion of inexpedient to legislate, please say yea. If you're opposed, please say nay. I do ask the members participating remotely to please activate their camera devices before the vote begins. Representative Bolden, it's just a request.
Vice Chairman Welch,
Aye.
Representative Byrd,
Yes.
Representative Hopper,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Doucette.
Yes.
The clerk votes yes. Representative Harry Gathright,
Yes.
Representative Pantelakis,
Yes.
Representative O'Hearn,
Yes.
Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman.
Chair votes yes.
Mr. Chairman, the vote is 21-0.
By a vote of 21 yeas and 0 nays, the motion of any being to legislate is passed. Consent. Representative True, to be a majority report?
Yes.
Thank you, Representative True. This time, we can now close the executive session on House Bill 443. This time, we are now going to open the public hearing on House Bill 315, adding trespass as an exception to the charge of criminal threatening.
How about,
The what?
how about 196?
Excuse me. We're done. And we all know the word, the phrase, point of order, right? We all know that?
It's 3:15 PM.
Excuse me, House Bill 196. Adding trespass to the exception to the charge of criminal threatening. Representative, make your center stage. Thank you.
Thank you, Chair, members of the committee. Glad to be back in the most exciting committee ever. No competition. My name is Michael Lipovich. I'm from Hooksett, representing Merrimack District 24. And today I'm presenting HB 196, which talks about this defensive use of firearms. I'm sorry, defensive display of firearms. We talked about the subject before. This one is also a simple clarification of our firearm law, where we're trying to prevent lives from being lost. We're trying to save lives. We're trying to de-escalate things. We really would like to not resort to the use of firearms. That's why we're trying. Sorry. That's why defensive display of firearm is a good thing. It's a solid thing. I believe it should be encouraged, because I'd rather everybody walk away peacefully from any encounter they ever faced in their lives, rather to resort to something else, to violence. So again, my changes are quite simple, just a few lines. They don't talk about the use of firearms. This is about displaying a firearm. Very similar to the bill you've previously heard here. Because, yes, and this change needs to be made in the chapter that deals with criminal trespassing and criminal threatening. My bill makes an exception to display a firearm in cases when there is criminal trespass going on. So again, I want to ensure that citizens who display a firearm, who are trying to warn of any potential trouble, do not face persecution of any kind. And this is what my bill is about. It's quite simple. Nothing to do with the use. It's only a display. So, thank you. I'll take questions.
Thank you, Representative, for your testimony. Representative Gathright, you recognize for a question.
Thank you. And thank you for taking my question. You say display and display definition is brandish if you are doing it for the purpose you just said.
Is there a
You
question
said
there?
Oh. Yes, would you believe? Sorry.
The way I have, I'm not an expert on English language. It's not my native tongue. So the way I have it described, display is something which you show, you make it visible, you make it known with an intent. Brandish, it contains an intent to cause harm to somebody else, I think. It is not defined in statute, but display is a common word.
Representative Colony.
Mr. Chairman, thank you, Representative. Well, I think what you're proposing is already covered quite well in statute. Would it be appropriate to read the current statute and then ask you to explain how your bill would differ? If I may.
Is that the question?
So yes, the question, so I will read the statute and then ask for clarity. So the statute currently reads 631:4, Section 4, a person who responds to a threat which would be considered by a reasonable person as likely to cause bodily injury or death to the person or to another by displaying a firearm or other means of self-defense with the intent to warn away the person making the threat shall not have committed a criminal act. That's the current statute. So I guess I'm wondering, how is this different if this is the current law that allows precisely what you're proposing? And I understand you don't have the law in front of you, and I'm sorry to put you at a disadvantage, but it sounds to me like it's already covered in law.
Thank you for the question. I believe trespass, criminal trespass, is not covered by the statute. So this is what we're trying to do, to add it to the statute about criminal trespass.
Representative Klein, I just may, although I believe your question is fair, we don't debate the witnesses. We inquire.
Understood.
It wasn't quite a debate, but that was close. Thank you. Representative Muse, you're recognized.
Mr. Chairman, and thank you, Representative. Is there a specific problem that this bill is trying to solve?
Well, I've heard, thank you for the question. I've heard a good number of folks coming to me looking at 2020 as being somewhat of an unusual year with riots, violence, dozens of people dying, a firebombing, businesses destroyed, homes destroyed, lives ruined, the summer of 2020. So those folks are worried here in New Hampshire. They want to be able to protect themselves. They want to be able to not be faced with violence, unnecessary violence. And this is what I'm doing here. Even in New Hampshire last summer, I believe there were small businesses that were quite in fear of being attacked when there were demonstrations throughout the cities. So in those cases, we had owners basically stand in front of the businesses trying to warn off the attackers. That worked. I believe that's a great defensive display of firearms. And this law makes the people who are scared of being attacked again not fear for the attack as much, because they know that we're behind them 100%, that we encourage the defensive display of firearm where there is a need, and they do not feel threatened anymore. So I want to make it, yeah. So yeah, that's where I'm coming from. Thank you.
Yeah. Representative Pantelakis, you're recognized for a question.
Muted.
Representative Pantelakis, you have to unmute yourself.
She unmuted herself.
I am. Okay,
Recognize Representative Hammond.
thank you, Mr. Chairman. And thank you, Representative, for taking my question. If the stores and other places want to do this, why would, if no one had damaged their place, why would this amount of $1,500 be in here?
Thank you for thank you for the question. $1,500 is actually part of the trespassing chapter. It's that's how criminal trespass is defined in 635:2.
Right.
We're dealing with, right? That's a different, yeah. 635:2 defines criminal trespass as misdemeanor or Class B felony. Subsequent offense if the person recklessly causes damage in excess of $1,500. Since this new chapter makes it an exception to the chapter about criminal trespass, we're just using that same dollar amount that the criminal trespass uses to delineate felony, Class B felony.
Thank you.
Representative Newman, you recognize?
Thank you, Mr. Chair, and thank you for Representative for taking the question. Are you aware? Are you aware that the way the bill is worded, at least in my opinion, is that it expands the ability to display a weapon to all forms of criminal trespass, where the current law protects a certain class of criminal contact? Is that correct?
Let me check. Thank you. Let me. You're able to display a firearm to someone who is criminally trespassing with a threat. You will be able to with this law. So I'm sorry. So the question, I'm sorry.
Mr. Chairman, follow up.
Representative Newman, you're recognized for a follow-up question.
Yes. Thank you, Mr. Chair. And do you agree that since it says the law of Section 4 in its entirety, that covers all of the definitions of criminal trespassing in that law?
I would agree. Yes. Criminal trespass. That's what we're trying to warn. Yeah.
Thank you.
Representative Wallace, you recognize?
Thank you, Mr. Chairman, and thank you, Representative, for taking my question. So this bill will provide legal protection to a property owner who is taking a defensive posture with a firearm or another means of self-defense to neutralize or de-escalate the threat in a criminal trespassing situation. Is that my understanding? Is that correct?
Yes, thank you. That's perfectly right.
Representative Gathright?
Thank you, Mr. Chair. I thank you for taking my question. When I look at 631.4, that is for certain government officials. And you're adding, I'm asking. So are you adding a new paragraph under government officials?
I think you're reading it wrong.
Yeah.
That's not.
It says criminal threatening, amend RSA 631-4.
That's right.
So he's adding 4 because it only goes to 3.
I'll go
Right.
for 4.
Mine's don't in this book. Did I do something, get something different?
Oh, the criminal trespass.
Oh, here. All right, I went over.
Page over. Yeah, it's right there. He's adding to that.
Okay. I apologize. I was actually looking at 631-4A. Sorry.
Okay, yeah. Thank you.
Seeing no further hands raised, I want to thank you, Representative, for your testimony. Chair now recognizes Elliot Axelman. With discretion, the chair will limit testimony to members of the public to 2 minutes.
Mr. Chairman, I don't see him.
Chair now recognizes Joe Hannon.
Good afternoon, members of the committee. Nice to see you all again. My name is Joe Hannon. I'm the Vice President for Gun Owners of New Hampshire, and I'm speaking in support of HB 196. I think there was one, I forget who said it, but there was mention that this is a difference between brandishing and displaying. I've just double checked. I went through the search. There's no word brandishing in the RSAs in New Hampshire. Display is the only reference to showing anything, whether it's firearms, fireworks, or whatever, what may have you. I think some of the confusion is that we're not allowed to use force in defense of premises or property. And there is already in the law, section 627(7), use of force in defense of premises, and a person in possession or control of premises or a person who is licensed or privileged to be thereon is justified in using non-deadly force upon another when and to the extent that he reasonably believes it is necessary to prevent or terminate the commission of a criminal trespass by such other in or upon such premises. But he may use deadly force under such circumstances only in defense of the person as described under RSA 627(4), or when he reasonably believes it is necessary to prevent an attempt by the trespasser to commit arson. So you can already use non-deadly force. So the display is certainly non-deadly force. It doesn't authorize someone to actually use that weapon, but it can be used as a warning. So in conjunction with the other statutes about using a firearm as a warning against serious bodily injury or death, I think that's almost a non-necessary part of the law, because if someone's going to seriously injure you or kill you, you have the right to not only show them your firearm or weapon, but you have the right to use it in defense of yourself. So this actually makes everything much more clear, and using non-deadly force in this bill does coincide with section 627(7), use of force in defense of premises. So it is non-deadly force. It's just a display of force. Thank you.
Thank you for your testimony. Oh, excuse me, Representative Bourdin, you're recognized for a question.
Thank you, Mr. Chair. Thank you, Mr. Cannon, for coming to testify and taking my question. Well, you noticed that brandishing is not defined in the in our laws, and neither is display. So are we going to say that they are equal?
We don't have to use either. We don't have to say they're equal. The word display is actually in our laws. And when there is no definition in the RSAs, the courts will use the standard definitions found in a dictionary.
Thank you.
You're welcome.
Seeing no further hands raised, witness is excused.
Thank you all. Have a good afternoon.
And if there's any members of the public who wish to testify, in attendance that haven't testified already, please raise your hands at this time. The chair now recognizes Alan Rice. Just a reminder, your testimony will be limited to 2 minutes.
Hello?
Yes, Mr. Rice, we can hear you.
Okay, thank you very much. Alan Rice, Gun Owners of America. Mr. Hannon did a very good job explaining the benefit to the bill. I just want to add in the questions about trespassing. Sometimes a trespass that starts out innocently enough becomes violent. And the person owning the property should not face criminal prosecution for holding, displaying any firearm. It's common to carry a handgun in a holster, but a rifle would be on a sling on a shoulder. A shotgun may just be cradled across the arms. And, defensive display, as we talked about in a prior bill a few weeks ago, is a very valid self-defense concept. So I just want to put Gun Owners of America on record in support of the bill. Keep it under 2 minutes, and I'm happy to entertain any questions.
Thank you, Mr. Rice, for your testimony. Representative Hopper, you're recognized for a question.
Thank you, Mr. Chair. What is your take on the part of the bill that says likely to cause property damage in excess of $1,500? How's that going to play out in court?
Well, $1,500, thank you for your question, Representative Hopper. $1,500 is the threshold in New Hampshire when vandalism of private property becomes a felony.
Seeing no further hands raised, I want to thank the witness for his testimony. Chair now recognizes Maria Perez.
Thank you, Mr. Chair. This is a State Representative Maria Perez, and I'm testifying against this bill. We don't need any more bills that is going to give people a right to, even though that people sometimes, like me myself, sometimes just walk around the neighborhood, and this kind of bill doesn't make me feel safe, because sometimes people just discriminate just because they don't like the way you look, they don't like the way you talk, or they just barely, or they just don't like you. And this is giving people the chance to, given the right to show their guns and then try to threaten you with the guns. And the other thing is, myself, I have people trespassing my house many times, my property. One of the occasions, someone trespassing my property and asked for my husband, and this person had the intention to argue with my husband and getting into a fight with my husband, and I say no. And this person pushed me on my own driveway. But personally, I don't respond to that, because if you know, yes, I'm a US citizen, but I'm an immigrant, and the laws threaten us differently, because even if we are US citizens, we don't have the same protection as someone who was born in here. So I believe this law, I will not support this 196, because it's not giving any protections for people from the minority groups when it comes to try to protect themselves and showing the gun when someone showing in the properties.
Thank you, Representative, for your testimony. Seeing no hands raised, Representative, you're excused. Ada, and then just for the record, please say your full name for the record. Where you're from, and then whether you will be testifying in support or opposition to House Bill 196.
Mr. Chairman, that person there, their hand was not up. I did ask them to unmute. I'm not sure if they wanted to speak. I think by accident they got down below by a technical problem, if I may say.
Oh,
So I do apologize for my technical problem.
no problem. At this time, the chair will recognize J.R. Hall. This is a reminder, your testimony is limited to 2 minutes.
Thank you, Mr. Chair. This is J.R. Hull for the record. Can you hear me?
Yes, we can hear you just fine.
Thank you. I am testifying on behalf of myself as well as the New Hampshire Firearms Coalition. I serve on the board of directors as the corporate secretary. We are in support of the bill as filed, and we agree with the testimony of both Gun Owners of America as well as Gun Owners of New Hampshire. And I think at a high level, no one should be penalized for simply displaying a firearm. That should not be considered a crime. And criminal threatening is already well defined in RSA 631 in terms of acts and behavior. And just merely holding a firearm, or in the case of Mr. Rice pointed out, right, carrying a shotgun around, potentially with both hands, if you're walking on your property, shouldn't be considered a crime by itself. The crime is the threatening part, and that's already well defined in statute. So I would ask that you would support the bill as is. If there's questions, I will gladly take them. Thank you.
Seeing no hands raised, the witness is excused.
Thank you.
If there's any members of the public who wish to testify that haven't testified already, please raise your hand. Seeing no hands raised, at this time we will close the public hearing on House Bill 196.
Mr. Chairman, on House Bill 196, we had 12 people sign in support of the bill, and we had 53 sign in opposition.
Thank you, Representative Muse. At this time,
Excuse me, could I make a comment on what we just had? That section that was amended by the last bill appears in 2 places in the RSA's. Same exact wording, and I put the bill in and I didn't know it was in 2 places.
Well, which RSA's are you referring?
Well, it appears in 631 colon 4 under criminal threatening. It also appears in 627 colon 4 physical force in defense of a person. Same exact words. Just a curiosity, I guess. I didn't realize I had amended it twice.
I wasn't here to say that.
That's a while back.
Just pass it anyway, you make sure it's safe.
Also,
Representative Yaffer.
can I make note of 2 people that are, or 2 organizations that oppose the bill? Would that be okay?
We're not in no formal hearing, so you may say it.
Okay. New Hampshire Legal Assistance and New Hampshire Coalition Against Domestic and Sexual Violence. And a slew of other people, but I thought it was worth noting some of the groups that we're consistently hearing from.
Can I ask a question, see, we're not doing anything specifically?
You may.
So somebody comes onto my property. I live way out in the woods. Somebody coming on my property, it's pretty deliberate. It's not like wandering off the street onto my property. and I walk out of my house with a shotgun, because I have no idea what the hell they're doing. I also don't know that they're gonna actually do any damage. If this law goes through, am I now guilty of brandishing a firearm? I mean, where I think I could bury the evidence pretty successfully, but.
Okay, let's just understand, the term brandishing is.
Or display.
Well, branding, yeah, but use the terms differently. Brandishing is defined in the federal.
Okay, anyway, I'm displaying my firearm, so I'm proud of it. And trying to encourage them to leave the property. Is it, if this passes, like right now, what would happen versus if this passes, what will happen?
In my opinion, and this is just my opinion, I don't feel that the mere act of displaying a firearm in the state of New Hampshire is a crime under any circumstance. Under the federal definition, what makes it brandishing is that when you display the firearm with the specific intent to intimidate or threaten someone. So that's what makes brandishing. It requires displaying, but it requires additional acts or intent to do something. So if you were simply just walking down the street open carrying in New Hampshire, which has been the law as long as I can remember, that is only considered displaying. Now, I would also say that if you were to take your firearm and point it at any individual, or even if, unless it's for a lawful reason to defend yourself, I don't feel that you can simply say, I am just displaying a firearm when it's that firearm being pointed at the person.
No, I would never do that unless they were actually threatening me. I'm talking, somebody's on my property, I don't know what they're doing, I walk out of the house with my shotgun. Am I guilty? Because I don't know, but they might be doing $100 damage.
Your property posted?
No.
As long as you don't point it at them.
You're not guilty.
I think I understand what you're saying about the dollar amount to be a concern, but.
The dollar amounts just screwed me up.
What we can do, Representative Hopper, is I know there's 2 executive sessions that we can get moving on. But I think this is something that we maybe have a further conversation as a committee in the executive session. I want to do some homework on this. I don't want to tell people they won't be guilty of a crime then.
No, I just want to use you as a defense if I get caught.
Yeah.
You'll probably need a better lawyer than this. At this time, we're opening the executive session on House Bill 205 relative to incarceration under a suspended sentence. The chair will recognize Representative True.
Thank you, Mr. Chair. Mr. Chair, I move House Bill 205 to retain.
And Mr. Chairman, if I may second that.
That motion's been seconded by Representative True. Representative Burke. Representative True, do you wish to speak to your motion to retain?
Thank you, Mr. Chair. I remain confused and bewildered on the 18 months of serving before 2/3 of the minimum sentence. If you're in for 6 years, 18 months before 2/3 of 6 years probably is not going to give you enough time to complete any programs that you may or may not need. I have questions on the bill that perhaps they might get answered if we retain the bill. Thank you, Mr. Chair.
Representative Muse, you recognize?
Yes, just a reminder that this was a bill that we passed 20-0 in the previous session. And the only thing that has really changed substantially in the bill is something that caused the New Hampshire Department of Corrections to endorse it. We also have endorsements of the bill from the ACLU and the New Hampshire Association of Criminal Defense Lawyers. I mean, this is a pretty good bill. And I know sometimes when you look at these things the first time, they can be a little confusing. But I think part of our job is to sort of sort through some of the confusion, not just to defer confusion until September or October when we can get around with it. we're not doing, based on some of our other votes, we haven't done a great deal for people who are incarcerated. I think everybody acknowledges that we have issues in our prison system with allowing too many people to be incarcerated beyond the time they probably should be. This is a bill that would help us address it in a very measured way. It's not extreme. It's not a get out of jail free card. All it essentially does is move up the time that somebody would be eligible to essentially to complete things that are required of them before their sentence could be suspended. And I am having a hard time understanding what we need to change about it. The bill was actually changed. That's what the amendment was about, in response to some of the concerns we had even last year. So I'm sort of at a loss as to why the ITL or the retain, but it is what it is.
Although there's no amendment offered, Representative Muse, do you mind just explaining the committee what that amendment were offered?
I'm sorry, Mr. Chair, I couldn't quite make out what you're saying.
There was an amendment going that's not offered, but it was just 205.
You can't offer it to an ITL.
Or for a retain, I'm aware.
You want it.
I'm aware.
I just want to make paper.
I think the issue is that the folks in the prison system felt that the original 18 months that was in the bill wouldn't give enough time for people who just qualify under the bill to be eligible for it. It wouldn't actually give them enough time to complete programs. But when you reduce that to 12 months, it means that they're actually serving more time so that there's time to complete those additional programs. So a lot of times when we look at 18 months to 12 months, it seems like, oh, we're being more lenient. In this particular case, we're making it a little bit more difficult for people to do this who are eligible, who might be eligible for this sooner. So, to me, this seemed to be a pretty good compromise to get this bill through.
Thank you, Representative Muse. Seeing no further hands raised, the matter we put the question. You're in favor of the motion to retain, please say yes. If you're opposed, please say nay. I would ask that the members that are participating remotely, please activate the cameras at this time.
Vice Chairman Welch.
Aye.
Representative Burt.
Yes.
Representative Hopper.
Yep.
Representative Green.
Yes.
Representative Wallace.
Yes.
Representative Testerman.
Yes.
Representative True.
Yay.
Representative Pratt. Representative Doucette.
Yes.
The clerk votes yes. Representative Harry Gaffrey.
No.
Representative Pantelakis.
No.
Representative O'Hearn.
No.
Representative Bourdonnais.
No.
Representative Muse.
No.
Newman.
No.
Representative Bolden.
No.
Representative Conley.
No.
Representative Pine Knight.
No.
Representative Bradley.
No.
Chairman.
Chair votes yes.
Vote is 11, yea, 10 nay.
By a vote of 11 yeas and 10 nays, the motion to retain is allowed or is passed. This time we will close the executive session on House Bill 205. This time we will now open the executive session on House Bill 576 as relative to victims' compensation fund eligibility. This time the chair recognizes Representative Welch to make a motion.
That we retain House Bill 576.
Is there a second to that? Representative Rhodes?
I would like to second that motion, please.
Representative Rhodes, please speak on the motion.
Once I get to the bill.
Okay.
I think what we need to do is to determine is where this fund comes from, where the money raised, whether or not it's taxpayer funds or some other funds. And I think we need to do that before it goes to the floor, that's all. If we retain it, we'll have a chance to check that out.
Representative Muse, you're recognized.
So I thought I heard in testimony that that there's no fiscal note on this bill because the money is coming from an established fund versus from the general fund, or did I hear that wrong?
Right.
I believe I asked the question of the witness. I believe Representative Bourdonnais provided an answer to that question, and that's my recollection.
Yes, Mr. Chairman, that is, as it is the way what happened, and I can't see any reason that we would want to retain this bill.
Oh, that fund gets depleted at some point, and the money has to come from somewhere to fill it up again. We just need to determine where that money comes from.
Representative Knight, you recognized?
Thank you. It comes from the Attorney General's office. It's online. Victims Compensation Program, Grants and Management in the state of New Hampshire.
Thank you, Representative Knight. Representative Pantelakis, you're recognized.
Thank you, Mr. Chair. It's my understanding if they run out of money, they run out of money. Nobody gets paid. This is just a special fund for that. Thank you.
Representative Gafford, you're recognized.
I want to say that was my understanding too. Last year when we had all those different bills and the money comes out of that fund, when it's gone, it's gone. At no point did anyone talk about going from the taxpayer or any of those types of things. So I think that we should be moving on with the bill. There's no reason really to retain it.
I will just let the members know we are meeting, scheduled to meet next Wednesday, and it is retained, and if anyone wants to bring forward some information to present to the chair and vice chair of the committee or the committee as a whole, as you can tell from today and other days, we've done reconsiderations in the past. But I think at this point, no matter we put the question, the clerk will call the roll. If you're in favor of the motion to retain, please say yay. If you are opposed, please say nay.
Vice Chairman Welch.
Aye.
Representative Burt.
Yes.
Representative Hopper.
Yes.
Representative Green.
Aye.
Representative Wallace.
Yes.
Representative Testerman.
Yes.
Representative True.
Yay.
Representative Pratt.
Yes.
Representative Doucette.
Yes.
Clerk votes yes. Representative Harry Gaffrey.
No.
Representative Pantelakis.
No.
Representative O'Hearn.
No.
Representative Bourdonnais.
Yes. Oh, no.
Representative Muse.
No.
Representative Newman.
No.
Representative Bolden.
No.
Representative Conley.
No.
Representative Klein Knight.
No.
Representative Bradley.
No.
Chairman.
Chair votes yes.
Mr. Chair, the vote is 11 yeas, 10 nays.
I vote
Surprise.
of 11 yeas and 10 nays, the motion retained.
I was surprised.
We're just remaining, just not speaking as residents. This time we'll now close the executive session on House Bill 576.
Who second that?
And just a reminder, next Wednesday, we are scheduled to meet. We are also it's going to be noticed in the calendar that we're scheduled for further executive sessions on Thursday. That will only be obviously if it's necessary for us to meet. If the idea is that we can get done, there may be some changes in the deadlines, but for now, that's how it's scheduled. So let's try to make good use of our time next Wednesday. President Hopper?
Is next Wednesday the one you wanted to stay very late?
Yeah.
Yes.
Could you appoint somebody, find a replacement for me then?
I will notify the speaker's office requesting a substitute result.
Follow up. So, seeing that I won't be here, if we take this previous bill back up, could somebody amend it so we finance that fund by selling the organs of the predators of traffic and human traffic? We need to sell their organs.
Really?
My God almighty.
President Hopper, that really wasn't necessary. On that note, the Criminal Justice Public Safety Committee.
Did I not hear him correct?
You heard him
I have an opportunity to represent the
I want to know if we're meeting next Monday.
Next Wednesday, we are meeting, not Monday.
And
All
that we probably if we're late, we will not have Thursday, correct?
If we finish everything, the idea,
Would I not be able to be here Thursday? I already can't change.
Yes, the meeting's done.
Don't know. They don't tell us much.
Well, I think it was adjourned. It's hard to tell, but I think we're adjourned, Laura.
Did I hear him right?
I believe you did, and it's probably not for discussion right now.
Okay.
The chairman is still there and we're still recording.
So we're not meeting on Monday at all.
No,
Wednesday.
not unless they change it and it's in the calendar, that might happen. But this is still being recorded as I understand, so. And apparently, I don't know whether they can't hear us in the room apparently, but I'm going to sign out now.
Me too.
Bye, everyone.
Bye-bye.